Behind every crime lies a story waiting to be uncovered, from chilling mysteries to untold truth. This is where the darkness comes to light.
Roaring buzz lights up the air, faces tense as stories tear, truth and lies like a tango dance. Justice here takes no chance. Gavel strikes, hearts beat fast. Witness takes stand, shadows cast. Whispers loud like wildfire spread. In this game, none's ahead.
Hello, good morning, everybody. So, how is everyone doing? I hope you are all right. Hello, good morning. There it is. Friday today. Yay, we made it to Friday, everybody. So we have quite a bit going on today. We have a hearing for Billy Wagner, the Pike County person thingy. Sorry, person thingy. That's what. Um. Oh, I don't know. I don't hear any echo. Um. So hang on. Is anyone echo? Is anyone having echo? Oh, no echo. Okay, let me know if you just Paula, maybe just go out and come back on the stream. Maybe it might be that. I don't know, my sweets. I'm so sorry about that. But good morning, Sissy. Good morning, Maria. Good morning, Hannah. Hi, everybody. Hi, William. Hello, everybody. Binny. Hello. Good morning, William. Happy Friday. It is Friday, y'all. So today we have lots going on. We are going to be going between Ohio and between Colorado, and then later on today we might go to Washington. So it is going to be a rather busy day for us today, and yeah. So, oh, Pickles! Hey, Pickles! You were here to say, Yep, I normally do. I'm on it. Thank you very much, Pickles. I'm a little bit slow today, even though I'm having a kind of monster. I'm a little bit slow. But it's all right, it's okay, Paula, it happens to everybody. You are here. I am so glad that you are. I'm so glad that every single one of you um are here today. So today the plan is we are going to be covering obviously this hearing for Billy Wagner, and then we are gonna be uh covering. We are still waiting on a verdict for the trial of the Joseph out of Colorado. um no, you're never in the wrong stream. You are in a very correct stream, my friend. So yeah, that's what's going to be. And then later today we're going to covering a sentencing of a case that we did not follow because he did not went to trial, but I am sure that if he had gone to trial we would be following, because I'm a case nut. What I'm going to do, I wanted to cover an interview with our friend Crazy Lori, but that I just literally saw a content creator that was doing exactly that same interview, and she got copyright strike. So we're not going to be following that. We're not going to be watching that here together. But I'm going to give you some homework, and you can do it on your own. So the link of that interview of Lori Vallow that she did after her sentencing is in the link below. Please go watch. It is rather entertaining. You know, she's cuckoo Lori all the time, and that interview, it's a showing. So I very high recommend to that. It is a very good watch for sure. Zizzy, I am crazy. I keep I my eyes. You know, today actually I need to share a picture on here that I wish one day this is me. Well, the thing is, some it's not content creators, some news stations, they do that. That's why I'm very like careful to what we stream on the channel, not to get copyrighted striked or getting in trouble, because I think that's the last thing we all want to do, and that's the last thing I want to do is to make put the channel and our whole effort in jeopardy. So definitely homework with me, it's fun, obviously, and always. But I'm trying to send something to my computer. So guys, I want to show you guys what one day would love to be my setup. I just need to turn on the Bluetooth on my computer. Trying to do this before anything goes live. Um, it is rather odd, isn't it, Anna? It's yeah. So hang on, let me just open the photo. And now I'm gonna stop sharing this for a second. We won't miss anything, don't worry. But I want to show you my hopefully will be my setup one day. This is my dream setup, guys. This is how many screens sometimes I wish I had, because I'm gonna tell you, I have three screens with the laptop, right? Then I have my iPad with me as well, and then I have my phone with me at all times, and that is my setup. I wish I had this setup that is on the screen. I mean, I would be the happiest girl in the world. Well, I am the happiest girl in the world because I've got garden bot and I've got every single one of you. But with this setup, I would be even happier. But let me go back to court because the hearing should be starting any minute now, and I don't want us to lose anything. And I also need to not talk too much. So I know it is a very nice setup because I am very, very jealous of that setup. Indeed, I wish one day when I grow up, when I'm like a big time adult person, I'll have a setup like that. So do not worry. I am still keeping an eye on our courtroom out of the Joseph verdict watch trial, but if something happens, we'll be bouncing back up and back. So I hope you guys are strapped in, have your passport ready because we're going to be traveling between Ohio and Colorado at least today, right now, and then later on we're going to go to Washington. So I hope you guys have a good day of journey of traveling around the US. Uh, so this court is in Ohio. Don't go up, it's a trap. Uh, um so this courtroom, we are in Ohio for the Billy Wagner's sentencing, and I call him Binny. I call garden bot because my husband is a gardener, does gardens for a living. He's a self-employed gardener in here in the UK, and he used to do the night shifts for us in covering trials, and I will always call him either garden bot or night bot, but we now call him garden bot because he does gardens. He's a gardener, and he's a real person, but he's also a bot that we call it. So it's just a suddenly funny, and something that we chose. But and the guys helped choosing that name. Actually, it was not me. It was everyone as like as together that we decided to. Yeah, actually, yeah, exactly. So it's just something like fun that we as a channel came together, and yeah, Green Fig is, oh yeah, he does. He's very good. I have to say because he is my husband, but he is very good as well. I do really like the work that he does, and many of his customers do too. So we haven't had like a big complaint so far, so you're good. Um, so this hearing is because the family of Billy Wagner has already been convicted of the massacre that happened in 2023. Oh no, sorry, I was reading the wrong part. Hang on, I was reading the where is it? I lost it. So is the last one of being ready for trial, right? In 2016, they all did. 8 members of the family of the Wagner family were accused of an execution style, um, unaliving. So he is the last one being standing for trial. All the other ones have already been sentenced. They already are appealing their cases. There's been motion on that one. And indeed, there is definitely a walking nightmare for family. So, oh, I'm gonna be whispering in your ears, Anna. Sorry, I won't do that again, but I like whispering in people's ears sometimes. Sorry, my apologies. Um, I apologize in advance because I'm already having an energy drink because I need one. I haven't been sleeping. As you know, it's been a very hard week this week. So I need a little bit of a pick me up. So I might have a bit too much energy, if you ask me. Um, Basically, yeah, that. Thank you, Zizi. I appreciate it. So basically that. So that's what we're gonna be doing today. We're gonna. I don't know how long this hearing is supposed to be. I am hoping that is a little bit so we can have something to do while we're doing on verdict watch. I am keeping an eye on the Colorado Judicial Branch website for our courtroom to go live. If they go live before um, for the verdict, otherwise we're just gonna wait until they come back for verdict. So guilty. Yes, indeed, guilty, Anna. I absolutely agree with you. Absolutely, 100%. This family is. It is a very, very weird, like weird family. Yes, indeed, weird with on weird. So yeah, so that's the plan of today. I mean, it is Friday, eve of the weekend. We've made it through the week. It's been one of those weeks. Telling you about it. But it is going to be a good end of the week. We're all going to have a great weekend, a relaxing one with our family, friends, doing garden work, just chilling. And then, um, yeah, then we're going to come back on Monday. I think we might have a new trial on Monday. I still don't know which one. I still don't know nothing. But hey, we're just gonna roll with the punches and figure out as we go, because that's what we do. Well, at least that's what I mean. I roll with the punches and then get nervous about something else. And that's the normal. That's me anyway. Um, so how is everyone today? Is everyone enjoying their Friday? I know Paul is very busy, and I hope that your day gets a little bit easier. But before you know it, it's gonna be the weekend, and you're gonna enjoy it. Oh, I forgot to like my own stream. So see, don't forget to leave your DNA on the like button. That does help a lot the channel. Like I forget to like my own stream, which it is very bad. Do not do that. Oh, are you in the garden again? Nice one. I mean, one of these days I definitely need to see your garden. Because it's very you do a lot in your garden, and I'm sure it is pretty indeed, because the amount of work and dedication that you have, it is amazing. So I would absolutely love it to see one day, maybe on my world tour, my US tour of next year. I'll be able to see it or something. I don't know, I'm just talking. They are about 5 minutes behind. What a surprise, surprise. Obviously Billy Wagner is in custody right now. I don't think he ever got bond or bail because of the situation and the aggravation of this case. Um, but yeah. Ooh. Oh, Anya. Who's Ned? I know you refer to Jed. It's fine. I'm joking. No, no. Ned's it's Laurie's. Is he Ned Flanders? Yes. He's the Ned Flanders or Ned from the uh Ned Flanders or from Laurie's Vallow, the Nephi. Oh man. Yeah, no, I am not gonna bring Chad. Definitely, I'm not gonna bring Chad Daybell. Oh, ew. Ew. But I'll definitely bring Anya. Absolutely, because I'm gonna kidnap my own niece. I went there today. She looks so good. I know she's my niece, and I have to say that, but she is gorgeous. She's absolutely the most gorgeous baby ever, and she's growing. It's like literally so. Ned from the yeah, I think that's the better Ned that we have is Ned from The Simpsons. Indeed, he's the best one, but he's the best one, but he's a little bit peculiar too. I'm not gonna lie, I really love like The Simpsons. Oh, yeah, I don't know if I told you guys, because I think we spoke about this, right? Me being talking all over the place, and this is the energy drink's fault. So my apologies. Um, oh wow. Well, it's not everyone's cup of tea, and I completely understand. Simpsons is not everyone's cup of tea, but it's one of my favorite shows. I recommend them, but it's absolutely up to you, my friend. I was gonna say, I know we spoke about this here. You guys know that show ER, right? The medical drama ER. Um, if you guys know, there's this character John Carter that is played by Noah Weil. I absolutely love that actor. Is one of my favorite actors. Guess what? He has a new TV show. Noah Weil is the lead character in the new show called The Pit. The Pit. Pit. Oh, I can't even speak. The Pit, and I am obsessed because I couldn't sleep last night. I watched about good 5, 6 episodes of that first show. I know. I watch that all the time. So that character now has a new show, and he's also a doctor, but it's like he's older. It's The Pit. I'm gonna put the name in the chat because probably the way I am saying it's not correct. But the name of the show that I'm watching with that actor is in the chat. It's called The Pit. I absolutely love it. I definitely recommend it. Watching cartoons seems not for me. Maybe. Well, it's not really cartoons. It's cartoony, yes, but the topics that they talk, it's everything. Um, it's everything but cartoony, but I agree. It's absolutely fine. It's okay. We still have a lot in common. We have true crime in common, so that is a great thing. We all have different tastes. For example, mine. I don't like horror movies. For example, even though I cover true crime stuff, I don't like horror movies. Go figure about that. So it's absolutely fine. I mean, it's absolutely okay. Because the thing is, I love people having differences, because like if we all like the same things, that would be very boring. We would not have anything to talk about. Like if I walk like the TV show ER and everyone liked that show, that would be a little bit boring. It would be good for like a minute or two, but then it would be good boring because we did not had anything else to talk about. I like that we all have differences, and that makes us and makes us human. So that's just me talking. I don't think I should have any more energy drinks before stream because I'm talking a lot, am I? Well, it's better talking a lot than talking nothing and be quiet. But I would prefer the court starts. Either one of the two courts that we are waiting, they could start. Like, I'm not gonna lie. Um, that would be funny that if now that we are here waiting for this hearing and the hearing not happening, um, energy is good. So should I have an energy drink every time before stream? Yes or no? I think I should say yes, because then Jed would be happy. Then he could have one as well. See, Zizzy says yes. Yeah, it's older. Yeah, ER is very yes. See, everyone's Jed, Garden Bot, everyone is supporting that have an energy drink before every stream. It says no, but I want to because that makes me a lot of speaking. So, um, Paula, that is not great, but yeah, I was. Paula says that she was bad enough and bought a 12 pack of Monster. You know what? I think next time we're going to Costco, I think I know what I'm gonna buy. I'll go without Garden Garden Bot says no, but we will talk about it. I know a bit exactly, isn't it? I agree too, because it's like I'm not a monotone person, and I know the past few days I haven't been the most a bit of myself, and I am trying to get back to. Obviously, I'm working through things out, and I will be a bit, and I am a bit right now, and I'm really looking forward to hang out with you guys today. We might have actually have a little bit of a break today, right? Because oh, that's weird. Because I was just saying we might have a bit of a break between here and what we're doing and the next sentencing that we're doing, or we might fill it out with another sentencing, because I've been in the streets of true crime, and apparently yesterday while we were stuck in Colorado, there was a lot of happening, and we might do something with our friend Zio together, because there's something we want to watch together. But I need to talk that. Oh, thank you very much. I sound fabulous today. I thank you very much. I do my sound fabulous, but I do not look like I am. Um. Oh, I know. You know. Let's talk about my pet beef with straws, okay? Paul says that she has discovered glass straws that she drinks her energy drinks from. She cannot handle straight from the can. And I agree. I don't like drinking from straight from a can. But one thing that I don't agree is paper straws. I am sorry. I do have metal straws, you know. I glass ones I probably would break it in my mouth and make my lips bleed and everything, and it would be a dramatic scene, as well as Zizzy. But I have metal straws, and I have to absolutely drink with a metal straw. Hey, Zio, see what happens, guys. I say Zio's name once, and she shows up. If that's not voodoo, I don't know what it is. Good morning, Zio. I am having an energy drink. Bottoms up. I need it. I After the morning that we had and the day that I've had so far, I definitely needed um an energy drink. And I had one in my drawer, so oh well. Yeah, I'm having it. Oh yes. Oh yeah, definitely, but metal straws is absolutely the best. I can't do paper. I'm sorry. I know we are supposed to save the environment, and that's why I used metal straws, but no paper ones. Definitely bottoms up. And now it's energy drink. Later might be an adult drink. Karen Reed, from what I know, Karen Reed has gone to the jury has gone to a viewing of the property of 34 Fairview. So yeah. Huh? What's Nightbot saying now? Oh, Nightbot, shut up. Hey, Case One, good morning. Hi, I'm waving to you through the portal of not having the camera on. Hello, good morning. Yeah, we're not watching Karen Reid, but I do know what's happening with it. So the jury and Karen Reid, they went to have a field visit to the crime scene, 34 Fairview. So that's why they're not on it at the moment. So um oh yeah, no, absolutely. And when we can yeah. I know. I will be back on screen on Monday, I promise. I still don't look very well, even though I sound better than I was. I'm still not there yet. But Zio says that she cannot tag anyone on the phone, but she's saying good morning everyone, and we're saying good morning back um as well to our dear friend Zio. So yeah. Um so the hearing should be beginning anytime soon. Yeah. So we just trying to wait for the either this hearing start or for our trial that is on verdict watch to start. I don't know if they're already there, if they are already deliberating. I do not know. So it's yeah, it's unknown right now, but we are waiting. We are gonna see what is happening. Also, to kind of promote the channel, I did a video, right, the this morning with Zio about a UK case, a UK a Northern Ireland case, about a fake live streamer. So I need to find if I can find the link for that video. If you haven't had a look, maybe on a break or later on during the weekend, have a look at the video. It is a very good case. It's the case of this guy in Northern Ireland that faked being on a live stream, and he unalived his wife, his fiance, his girlfriend at the time. So check it out. I'm trying to post the sorry, excuse me, the link in chat so you can have a look. It is there. So yeah. Oh, okay. All right. I'll see you and we'll entertain you, Paula. That is absolutely not a problem. Definitely can do some entertaining there. So that is actually a very good case that is happening in the Northern Ireland, and I am planning to follow either by going to the courthouse and try to report live from there, or try to follow it here. We'll see how it is and how is it going. So we're still waiting for the hearing to start. Our case hasn't started, so we'll just hang out and yeah. Sorry, I just need to report. I will answer this. Um, I since 2016, this is just like very very long time, almost 10 years. Can you believe it? Almost 10 years that this case has like this is crazy. This is absolutely crazy. Um, Thank you. Oh, we've got sound.
So, 2018 CR 157 said about Mrs. George Wagner III. And the case is set for our regularly scheduled appearances. The attorneys of record are still here today, and first issue to deal with is Mr. Wagner's not here, so how does the defense handle this? Mr. Hayes?
Thank you, Mayor. Please support Mark Collins on behalf of Mr. Wagner. Your Honor, we would formally waive his appearance for this hearing. This is kind of a legal hearing with some arguments that are going to be made as well as some procedural aspects. We're very grateful that Mr. Wagner was able to take away time. We've been able to see him much more frequently because of that. And we've explained that sometimes he might be here, sometimes he might not in general, depending on how many of these status hearings we set. And so he was okay with that concept. So for the record, we formally waived that. It's my understanding that for whatever reason, he has not even been, no one's there to pick him up yet. So since everyone's here, ready to go, including the victim's family, we're fine with waiving that at this point in time in his presence.
Okay, thanks. Is there any position the state has on that?
Obviously, I do believe this is the court's decision if they're okay with that. My only trepidation a little bit is that even that kind of case, although currently the steps have been dismissed, I think in that situation, we don't know that his appearance can be waived. I think he has a right to be here for every hearing, but I would defer to the court on this.
Okay. I would just want to let you stake out your position.
I'm sorry, but
I wanted you to stake out your position, so you don't have one to speak of.
deferring to the court.
Yeah. Something else, Mr. Ryan?
No.
So it's a privilege and a right of the defendants to use or waive. I think he fully can. I mean, the circumstances of the death penalty case, like every case, need to be considered to their fullest extent. So I'm willing to accept the waiver proceeds. We can reconstruct the record if we need. It's how you want to handle it. So I appreciate the fact you want to be productive when it comes down to it, Mr. Collins, Mr. Hayes. So we'll go ahead without it. I sent an email out where I outlined what I thought we needed to do today. And doesn't necessarily have to be in that order because I didn't bring the email. But there are a lot of issues to go with. So I'm willing to, I guess, tip it off. But there's motions from the victim's perspective. So, Ms. Gall, how do we want to go about those? Do you have a preference?
Good morning, Your Honor. Maureen Ball on behalf of victim TR and representative TR. I don't have a preference. I think based on the defense's response.
Hang on. Now go.
Based on the defense's response, pointing out that there hasn't been a legal finding of TR as a victim, it probably makes sense to start there. If he's not found to be a victim by this court, then he wouldn't have any rights after that. So that might be the best place to start. And that was the most recent motion that was filed on April 7th, 2025. The designation as motion for designation as victim
that too fast for me?
Sorry, I can slow down.
Most of us understand that we speak faster than people can write. We don't think about it because it's not our job. I've suggested to the court reporter anytime she needs to stop the whole thing, she will.
All right, just wave me down.
So when Mr. Collins hands her papers while you're talking, it gets a little overwhelming. But we all do it inadvertently, no big deal. Did you get all that from everybody?
Yes, sir.
Thank you. So there was a response from the defense, so we'll just take it in that order. You're welcome to go first with your motion with regard to victim designation.
Okay, Your Honor. Thank you, and may it please the court. So I guess procedurally, it might make sense to go through how we got here. Judge Corbin did issue a decision denying the defendant's change of venue request back in November of 2023.
Were we on victims representation?
Yes, but they raised the issue in their response to change of venue,
I
so
know,
I
but
wasn't
I
sure.
asked you to talk about the victim representation, not change of venue.
Okay.
Thank you.
So the victim definition under Ohio Constitution, Article 1, Section 10AD, and Revised Code Section 2930-01H is an individual who is directly and proximately harmed by the criminal offense. Victim TR is the brother of a deceased victim, in this case, Chris Roden Sr. I do believe that the murder of his sibling does cause direct and proximate effects and harm on him, both emotionally, psychologically. And then there's the financial aspect. He has, taken the time to drive to and from court, to attend these hearings throughout all of the defendant's cases. But most recently, this one, he is here today. He's taking off work in order to be here. These are ongoing effects that are going to continue to affect the way he lives for the rest of his life. There are several courts in Ohio that have upheld the victim definition in a very broad circumstance. They've held that banks are victims. They've held that an Uber driver not identified in an indictment was a victim. They've held that a law firm was a victim. And most recently, the 5th District did uphold a victim definition for parents, siblings, and nephews of a deceased victim. So I would submit that he does meet that legal definition as a victim directly. As far as the victim representative portion of this, there is no law that I'm aware of that requires this court to designate a victim representative. So I would ask the court to take judicial notice that he is acting as a victim representative in this circumstance. I do have some updated victims' rights request forms that I can file with the court where victims in this case have designated him as a victim representative. I think notably it's important that we look to revise code section 2930-02 that allows a victim to exercise their rights with a victim representative or have the victim representative exercise those rights on their behalf. So taking judicial notice that he's acting in that capacity does not dilute any other victim's voice in this process. Thank you, Your Honor.
Thank you very much. I'll come back at you, but go ahead, Mr. Hayes.
Your Honor, we leave it up to the court's discretion if TR is a listed victim in the case. We're not taking an objection to that at this juncture of time. I think it's within the court's purview and within the court's discretion. We do take into account, and we briefed it, so I don't need to go through everything with this. If they have standing to argue this, and if they have standing to argue against the change of venue, we believe that they do not. And the statute doesn't provide them that standing to do that, so we object on the record based on that. But whether TR is a listed victim, we leave that to the court's discretion. However, we do object to the standing that they would have to argue motions to be part of the proceedings.
Which is why I cut her off early.
I'm sorry?
Which is why I cut her off early when she went the other direction. Back to you, Ms. Cole.
Your Honor, in response to standing, victims do absolutely have standing assert their rights and challenge any denial of their rights.
What are their rights?
They have the right to be present, the right to be heard. Those are the two that are most prominent today.
No. You don't get a budget. What are their rights?
They have rights under the Ohio Constitution.
understand.
Article
What are they?
Section 10A. You want me to list all of them? I don't have them in front of me, but they have the right to be present, the right to be heard, the right to restitution, the right to object to unreasonable delay, the right to fairness and respect for their safety, dignity, and privacy. They have the right to an attorney, but not an appointed one, and that's under the revised code section. I think that covers all the rights that I would assert here today. The three that we would be asserting here today are the right to be present, the right to be heard, and the right to dignity and respect for their safety, dignity, and privacy.
Yeah, the right to confer with the attorney for the state, and I brought up previously that the state doesn't represent the victims.
Correct, Your Honor, I would agree.
Essentially, the state's attorney represents the state and talks to the victims, doesn't give them advice, doesn't owe them a duty, right?
Correct.
If there's 10 enumerated rights, you did a fine job checking them off.
Thank you.
But to steal Mr. Hayes' thunder, I don't know that you represent the state any more than the state represents your client, correct?
I do not represent the state. I am not a prosecutor.
That was your point, right, Mr. Hayes?
Yes.
Okay. Is this the first request, Ms. Dahl? Like, I didn't read the whole file. In this case, was there a previous request to designate TR as the victim's representative?
No, Your Honor, I only brought that to the court's attention based on the response and the change of venue motion from the defense.
Okay. Like, I only started this last June, so, and you got here after that.
Yeah, I didn't come in until December, so I'm behind.
Like, in your experience, has there been a deprivation of your client's 10 enumerated rights?
Your Honor, we appealed the change of venue decision from this court based on the argument that they were not heard at that hearing about how a change of venue would impact their right to be present. And the Fourth Appellate District said that the decision we appealed was not final because the venue had not yet been changed, and so they couldn't weigh in on anything else.
Yeah, they went farther than that, actually, to discuss what you're allowed to participate in, Mr. Hayes' standing argument. I'm just going to want to know if Ms. Canepa is going to cede you the right to talk about her objection to changing venue. So let's put you on the spot and let me know if you consider her now a representative of the state to argue the motion that you oppose.
Your Honor, yes. The state's interests align with the victim's interests in this.
Yeah, but that's not the same as ceding representation. So I would need to know if she's speaking on your behalf.
Your Honor, I can answer that.
I didn't ask you. I want her opinion because it's her turn to talk. I know you don't have an opinion, but I need her position.
I think it was, I think it's tricky, I guess, because this court has made it very clear that the state does not represent the victim's rights. And while I did make those arguments during the change of venue, some of those arguments, the hardship that this created on the victims and basically operates as an exclusion of them from the hearings because of those hardships. It was our understanding from the court's position that if they wanted to be heard on that matter, they needed to have their own attorney asserting those rights for them. And that's when Ms. Gow became their attorney, so that she could directly represent their interests. Again, I feel like it's still a state argument, the hardship on the victims, the hardship on the witnesses, all that stuff. So to the extent that her arguments are our arguments,
That's alignment. I agree that you're aligned on your expectations and goals and philosophy. But mine's a question of representation and whether her speaking is you speaking. Her legal duty to represent a client is your duty to represent a client.
I mean, she's not appointed as a state's attorney, representing the prosecution of this case. But again, I mean, she is representing the victim's interest, which we also believe we are supposed to be asserting. So, I know I'm not answering your question.
Yeah, I'm not sure if it's a lack of knowledge or inconvenient, because it's a huge deal with regard to who represents whom. Like, I don't want to hear a lawyer speak for some other party because they can't. The way you can't represent the victims, in my opinion, is the way the victim's attorney can't speak for the state. I have to look at one table and realize there's different clients. I do it all the time. So do you with regard to multiple defendants in trials simultaneously, right?
Sure.
It's a big deal. And we can't blur this line. She's going to want to speak on reconsideration of a motion. And I got to decide if I'm hearing you when her mouth moves legally.
Well, I do intend to provide supportive arguments in this matter.
Yeah, but now we're back to the waffling. Go ahead. It's a, first of all, like there's a lot of discussion in the judiciary about the new rights that are co-equal to the defendants because of the Constitution. We're all getting used to a law that we thought we knew, but we're watching it being expanded and contracted and explained. I put in my routine regularly now that the state doesn't speak for the victim, nor give them advice. And if they have the wrong impression, it's their wrong impression. There's no legal duty. No victim's allowed to sue the prosecutor for bad advice.
Right. No, I mean, obviously Ms. Gow represents the victims in this case.
Period. Only.
Period.
It's a big period. It's a big only. Right? Would you agree?
I believe so, yes, because there may be times where her position is different than the state's.
Okay. I don't think this is hard, but it'll get hard when we start applying concepts.
Yeah, and again, and that's what I was talking about, kind of that trick bet, because while I would be happy to carry the torch for the victims, this court has made it clear that I cannot. But in order for them to.
No, the law makes it clear. I'm just
Okay.
delivering the law.
Okay.
It's not a discretionary item. It's a huge deal.
Okay.
Because I get abuse of discretion thrown at me when in fact I'm just speaking what the law requires me to say.
Yeah. But then in order for the victims to be heard and there to be any real meaning to that requirement, we have an attorney and she needs to be heard.
And as far as I know, I've got to ask her again, she's had that opportunity. Like I try to acknowledge her every time she's gotten here and invited her to sit in the front when she chose to sit in the back. So there wouldn't be the impression it's a lesser relationship. Like, am I supposed to have a seat at the table for the victim representative, Ms. Gall, moving forward the same way the state has their representative right behind them? I'm like totally willing to accommodate that. But like people have to talk to me about their expectation of their rights, because if he's designated the victim representative, do I pull another table? Do I offer you another table and you get the choice? Like I'm not trying to step on anybody's rights. I'm trying to get it right. But you have to talk to me about what you think's going on, and then I have to decide if it's the right application of the law. Okay? So like run it through your list of things and understand is, do you want your victim representative sitting at counsel table or not if I designated that? Go.
You want me to take
Yeah,
it?
go ahead.
No, Your Honor, that's not something that I'm asking, and I don't think that's something that victim TR wants to do, it's just a
Yeah,
family.
thanks, that helps me. But if in 4 months you came back and I never asked, you didn't request it, I get second guess.
Your Honor, not by me in that circumstance. I would like to make a clear record on who I represent, though. I don't represent the state's interests. I have I didn't in my motion, my written motion, and I won't here today make arguments for the state. My sole purpose as the legal representative for victim TR is to make sure that his voice is heard, and the effects of a change of venue would implicate his right to be present at trial. There are hardships that the entire surviving family would see from that, and that's all I'm here to present today is that victim perspective. I don't think that there was an opportunity for that in the last hearing, and the appellate court stated in their opinion that appellant didn't ask for that. They weren't represented at that time. I don't think most victims would stand up and object in a courtroom in the middle of a hearing, and I think that's an unfair assumption or expectation on the victim. So all I'm asking is that you reconsider the decision you made with voices from the victims, specifically explaining to you the hardships that would be put in place by a change of venue.
Equally unfair is for somebody sitting at counsel table to impute to the court knowledge of something that was never raised. And that's why I asked specifically, has there been an occasion where the court inadvertently or intentionally violated any of your rights, any of your client's rights, any victim's rights? Like, I want to know about it so I can not do it again, because nobody said anything, so therefore silence is acquiescence until the second guessing shows up. Like, it happens all the time. I don't find fault with it, but if it's judicial second guessing, like, I don't want to get hung with that again, ever. I want to learn. So that's the segue then, is if I designate a victim representative and we have an opportunity for a representative to speak, who do I ask to speak? The victim representative or anybody who's related and is a victim. Like, did I just lessen rights by designating a victim representative? Because I said there's one victim and the other 5 people that have a right to speak, in my opinion, now don't. So you want to chew on that since you did the segue? You
Yes,
want other
sir.
people to speak, right?
Yeah, so the law says that a victim can exercise their rights on their own or with a victim representative. So the law supports that all 5 of those victims in your hypothetical situation would be able to speak.
Yeah, I'm going to give that. I'm going to
Okay.
give them that. Let's understand, I'm not trying to limit your rights.
Okay.
But I don't want you to inadvertently tie my hands by designating, asking me to designate, right? And then all of a sudden you find out that you closed the door that I didn't think should have been closed, and I'm stuck with it. So I don't intend to limit anybody's rights. At the sentencing hearings, people spoke their minds forcefully and appropriately, right? Like, we're going to do that as long as it's appropriate. I just don't want you to inadvertently limit what I think is appropriate.
Yes, Your Honor.
Okay?
The
Yeah.
victim's rights request form allows victims to designate a victim representative, and so that victim representative can receive notice on behalf of them.
Talk about this.
Yeah,
Right.
so that would be my argument, and that is that even if this court did take judicial notice as that TR is acting as a victim representative, that doesn't tie anyone's hands as far as the rights that other victims can exercise with him or on their own.
The problem with forms is they imply things they don't mean to imply. Because here they list a victim, singular, and then below it they say victim representative, which I think means an advocate or a lawyer. Like, I'm not intending to limit anybody's rights, but if the defense hears a lot of things that they think are damaging and wants me to say they don't qualify as a victim, then I got to get my hands wrapped around what you asked for and whether they're right. I don't have this form. You have a victim rep, they get one very damaging statement, not 5 or 15, right? Like I don't tend to be narrow in my application of victims' rights. But if you close and tie my hands, then that's on you, not on me. Like the whole concept of invited error.
Yeah,
Still,
strategy, right?
no, it's not strategy rights, it's substantive rights.
Okay.
It's because you represent TR, right?
Yes,
Well, what about all those other people? Do you represent them?
I don't have an engagement letter with each victim in this case now.
See where this goes? Like,
But
who's the next
he
victim?
That's why I'm asking that this court take judicial notice that he is representing the interest of
Well, I
many
think so.
victims. I think all of the victims in this case are in alignment with, moving this case forward and hopefully achieving justice. I think is.
But if they're not aligned, how many victims, lawyers do I get? 5, if there's 5 victims?
Well, I only
9?
know of 3 in the whole state, so I don't know if you get 5 or not. We have to find some more.
I'm not finding them, but they have the right to get their own,
Right?
right?
Yes.
Alignment's a really cool thing until it's not.
Correct. But I think as long as they are in alignment, a victim representative can voice that alignment and that interest on behalf of many individuals that are unable to attend each and every hearing for whatever reason, whether it be health, school obligations with the orphaned children, and I don't want to get into an argument.
No,
I'm not
this is
listening
healthy
to it.
discussion. Like,
Okay.
this isn't argument.
Okay.
It's argument, but it's not argumentative.
Right.
I
That's
let
what
Miss
I meant.
Canepa, I let Miss Canepa come at me.
Okay.
And some people thought it was like disrespectful, when in fact I found it engaging. Like she raised her voice, but I wasn't offended because it was a heated, passionate issue. Like, would I let her do that again? Yeah, as long as she was professional and like engaged, didn't take it to a personal level, and she didn't. Like that's perfectly, that's what we do in this room, right? If you don't have like a firm conviction in your position, just get out. Just don't demean the judge or the system or take it personal, and we'll all get along fine.
We're all on the same page.
Wait till you have to tell one of the family members that you can't listen to them because it's not consistent with your client's position. And good luck figuring out what to do, because Ms. Canepa faces that, Mr. O'Brien faces that risk all the time when they have to figure out who they listen to when they're just giving information, right? Been there, done that. I got this t-shirt. I got the scars on my back when the victims turn on the prosecutor. We just sort it out. Like if anybody says easy today, they don't understand what we're doing. Okay, do you have anything else on the victim representative issue?
No, Your Honor, I don't believe so. Not at
On that issue, like I'm gonna give you a
Yeah,
chance.
not on that. Yeah, not on that point.
Mr. Hayes, you want to like jump in here? You don't have to, but
Judge, just reiterate our previous points. I believe they're party to the action. Victims have a right to be present in the courtroom. Nothing that this court ever ruled, and the ruling on November 25th. Nobody's ever barred them from the courtroom. They have a right to be present. That right is always been for victims.
thank you. I appreciate your position. Ms. Canepa, Mr. O'Brien, like I haven't asked you if you want to make a record, talk on the thing.
On the victim.
Yeah, like on this last discussion we had. Ms. Gall.
Representation, yeah, and it's my understanding, I don't know if Ms. Dow brought this out, I think you may have, but there are a number of other victims present who have signed a form saying that they want TR to be their victim representative. So, to our knowledge at this point, there's no victim that is not in favor of him being the kind of spokesman. So yes, and I would say, the court's decision certainly substantially impairs the victim's rights, we believe. And so we would believe they do have standing at this time to at least present considerations.
So the decision on designating a victim's representative is deferred pending today, so I'll get your decision. I'm not just gonna announce from the bench. Like, I hope you did hear me say I'm not interested in limiting victims' rights and don't want to do so inadvertently. Okay?
Can I just add one thing, Your Honor? Just per the law, and defense didn't offer any, I don't think this court has to interpret any law, and they can just take judicial notice that he is acting as a victim representative. As far as the victim definition of TR, though, that is a legal finding that this court would need to make, and it would implicate whether or not we have any rights when it comes to the change of venue. So I'm not sure whether the court plans to hear or determine standing at this point in time.
I'm gonna let you explain how victims' rights articulated in the Constitution crash into the change of venues rules. I'm gonna let you argue that.
Okay.
Not gonna concede that you have the right to. That's the standing defense put up, right?
Correct.
And if I find you don't have standing, I just ignore everything you said necessarily. But if I don't hear it, I don't know what I'm doing wrong. Right? Like, there was a pretty good argument with regard to, not agreement, oral argument with regard to whether change of venue is appropriate or not. I wrote a decision. Everybody's welcome to like it or not like it. It's not the job. But then I apparently didn't hear enough of your perspective. So I'm going to hear some more of your perspective, which does not imply anything other than I want to hear. There's a motion, but it doesn't necessarily imply that you have standing. Just want to know what I don't know. Make sense?
Yes, Your Honor.
Have at it.
Okay. So just procedurally, I think it makes sense to make a clear record of how we got here. In November of 2023, Judge Corbin issued a decision denying the defendant's change of venue request without prejudice. In September of 2024, the defense filed an amended motion for change of venue before this court. After Judge Corbin had retired, the state filed an opposition, and oral argument was held on October 7th, 2024. There were victims present. This court did identify that on the record. This court also identified that the state doesn't represent the victims, and the state very briefly said that the victim's right to be present and interest in attending the trial would be affected by a change of venue. I, as legal counsel for victim TR, filed a notice of appeal that was then dismissed because the decision from this court did not identify the venue. It said it will change the venue and identify it at a time appropriate. So based on that, it was a lack of a final appealable order. And then this court instructed a briefing schedule saying that victim TR should submit any documentation or support in regards to change of venue. And that is when victim TR filed a motion for reconsideration of the change of venue.
So do you want to put evidence on, or just your argument proper?
So I do not have one of the victims that would like to be heard here today due to school obligations with the orphaned children. So I have 3 statements that I would like to read into the record and submit as exhibits. I did notify the defense of that. I'm not sure whether there will be an objection or not.
Good to know. What do you think, Mr. Hayes?
Judge, one, I'm not sure who these letters are from, if they're from TR or from some other parties. We've never seen the letters, never been provided the letters. Just briefly before the hearing today, indicated she had some letters, what our position is. So at this point in time, we would object.
So you want to recess?
Yeah.
Okay. Do you have copies that you might be able to show?
I do, Your Honor. I have 8 copies of each for the court and defense and state.
you'd like marked with numbers?
Not as of now, I can identify them as exhibits if the court would like.
No, I don't like to, I have to. If you're getting ready to introduce to the record something the court reporter needs to be able to identify, so call them victim 1, 2, 3, or victim ABC, or whatever it is you want, put a date below it.
They are each dated as letters, April 25th, 2025, but I can write the date on here too.
That'll work.
Would you like some stickers?
Sure.
So let's take a recess, standing break. Don't run away off the record.
All right, so we are in a little bit
Oh, yeah.
of a break.
Something like that.
That way they're not.
Yeah, thank you.
Stay.
Yep.
Sorry, just seeing the hot mic moment. 1 second.
Was it mail? That's a lot. That is. Is that how you're thinking? Yes. So am I. The question is where to come from. No. I don't know how great too many spy movies. Yeah, that's right. Yeah. Yeah. Oh, that's right. Yeah.
We have some hot mic moments.
To make it fair. Yeah. To make it fair.
All right, so finally they get the audio. So we had some hot mic moments there, but this court, it is spicy. I hope I am not too loud to you all. But I'm so sorry. YouTube sometimes has troubles. Like I send messages sometimes, right, on chat, and it just doesn't go through because I was like, I'm looking, and people don't reply, and I'm like, hello, YouTube, like, are you working? Sometimes it doesn't, but this judge is very, very spicy, guys. He is. In the last hearing that I saw for this case, right? He literally was having a screaming match with the lead prosecutor. The lead prosecutor is the tall, uh, bleach blonde girl that is in the courtroom, not the one that's wearing the pink. The pink suit lady is the victim's rights attorney that's been the long that she was arguing this morning. But so it is this judge is absolutely spicy. So that's why I was like, but the one thing that I'm sad about is, so I can give you that's good. And we need to tell him to calm down. You need to calm down, Judge. It's only 7 a.m. No, I'm joking. It's not, well, at least not for me. What I was gonna say is because I have to boost the sound so much in this courtroom. Hi, Jade. Good morning. Hi, hello. Good morning, and welcome in, my friend. Nice to see you once again. Good morning. Happy Friday. It is Friday. We made it. So yeah, I was so glad to see you, Jade. But what I was saying is because I have to boost the sound so much for you guys to have a good listen, because this courtroom is a little bit low. I do need to check if my booster is on. I have to reboost it again on the screen, so to make sure that you guys have a good sound. In my headphones, it literally like music blaring in my ears, so I don't have my headphones on. I had to turn on my iPad on and watch my own live stream so I could kind of make sense of what they're saying. And even though that I struggle, so I know the sound is not the greatest, and I do apologize for that, but we're trying to do our best for it, and I'm trying to boost it as much as I can. But this courtroom is a little bit low, which sucks because we've been having so many good courtrooms that have beautiful sounds, beautiful like microphones and everything. And now this one is not the greatest. And it's like, oh, come on. We just had such a good streak with good courtroom audio that we've been spoiled indeed. So, oh, that is awesome. I really appreciate you guys recommending the channel. It is amazing. And we do try our best to welcome everybody in and yeah, enjoy court and enjoy trials because that's what we do here. So, oh yes, we are really laid back. There's the only thing is you have to be careful is with Nightbot, the one the little bot is around roams around the chat. It doesn't like caps, so it has an issue with that. Apart from that, you're pretty laid back. um so yeah, so today, our courtroom line, like the Jefferson courtroom in Colorado, they haven't been in yet. So it is like 9 nearly 9 a.m. over there, and they haven't been on yet. So I don't know if the jury went straight to deliberations, which I am assuming they have. um I am assuming that they have, but I'm trying, all the other Jefferson counties, courtrooms from that county. I'm looking to see if the judge is any other courtroom, but it is not. So I am literally being like a stalker on and checking if they've come on or not. So don't worry, I'm keeping an eye out. I do need to turn on the other source, the Court TV source, so I can see for when, because sometimes they know about the verdict before they do come back, but it's always a struggle to put that up because with the VPN. So um oh oh
You got
hang on, I think they're back. Wow, that was a quick
No,
break.
not yet. I wasn't sure.
Oh, that's good to know.
well, like, hang
Thank you
on,
very much for that.
because
I'm
arguably,
approaching, we're not on the record.
yeah, but arguably you could say I'm not supposed to have those. No, get it?
Am I supposed to have it yet?
Yeah, so we're going to.
Put it down there, okay, because that's the record. No, I don't want to like.
Man, they need to stop playing with the audio. But yeah, Jay, thank you very much for that. I am a very good detective. Oh no. Sorry, see, I did told you that I had my iPad with my own sound to make
It's
sure
a
that
minute break to organize the documents, so Ms. Gall, you're on the record, go ahead.
Your Honor, we've already addressed standing, you said you would make a decision, so moving on to change of venue. The victims have the right to be present and heard at any time there's a public proceeding and any time their rights are implicated. With relation to the criminal offense, their rights are absolutely implicated by a change of venue. We are,
Which right is implicated?
their right to be present. It's substantially impeded by a change of venue, specifically based on distance. We are not aware of what county this court is changing the venue to. And so had they addressed the court back in October, what they would have presented is that some of them have taken in the orphaned children that are now of school age and have to get on and off the bus every day. Some of them are blue collar workers who can't afford to take off for a month. One individual.
Is that not the case in every criminal matter? Like whether you drive to Waverly or whether you drive to Hamilton, is it not the same implication? It's an inconvenience to have to come to downtown Waverly if you live in the northwest corner of Pike County.
Absolutely, it is, Your Honor.
Okay, so how do I sort out when the rights are violated? So it's like just geography, and I can take 25 miles is reasonable, and anything over, is there an objective standard?
Your Honor, I think the right here is the right to be heard. victims have a voice in the process, and these three statements explain what the effect would be of a change of venue, which is why I asked to proffer those in as exhibits. TR is here and willing to take the stand if you'd like me to direct examine him on the effects that this would have on him specifically. I wasn't going to do that. I was going to let the statement speak for itself. But he specifically speaks for his mother, who's also an 82-year-old elderly woman with health issues. And so, yeah, moving this out of Pike County would just be unfeasible. And it doesn't offer an opportunity for them to exercise the right to be present.
So does the defense have, first of all, you had a chance to look at the three exhibits, right?
Yes.
Okay, so do you have a position, Mr. Hayes, with regard to the court being made privy to the contents of the material as evidentiary matters?
As an evidentiary matter, no, the court can take it into consideration, but whatever way the court deems appropriate.
It doesn't cash in or concede the standing issue. Like I said,
Correct.
I want to state the obvious.
Correct. Just like a bond hearing, the court can take in other factors, other issues, so no objection based on it.
So I'll consider the substance. I'm never going to tell who to call. Now, never's not fair. I rarely call my own witnesses. So if you have witnesses, then you're welcome to call them. I'm not telling you to call them.
Yes, Your Honor.
I'll
And
take
I
the
would
letters though.
prefer not to. I would move to admit exhibits V1, V2, and V3. I can also read them into the record.
No, just give me the three, because Mr. Hayes has conceded that I can consider the substance. It doesn't concede standing, so,
Madam President.
yeah, thanks. Assuming, of course, you think that the letters don't violate the client's rights.
No, Your Honor, the letters do not violate the client's rights. It offers them a voice in the matter, and I do concede with the defense that it's the judge's discretion, it's the court's discretion to weigh this matter, and all of the evidence presented. Again, I want to clarify that what I represent is the victim's interest and their voice in this process. They did not address the court in November, and that's why we're asking for a reconsideration of the court's decision. They do, in the Constitution, it says that their rights should be protected in a manner no less vigorous than the defendants. Defendants have to waive their right to be present at trial, whether that's in writing or on the record orally. Here, there's been a lot of choice and choose wording in both the defendant's arguments and in their written brief response. And, I would proffer to this court that there is no choice. If this moves outside of this county, that takes away their choice. Like I said, there are children involved.
Do you now understand why I will not let you not appear? You said you were entering a limited appearance, but you wouldn't go to trial, and I refused that. So you have to show up. Do you understand why?
Your Honor, I don't know that this court has the
Oh,
authority.
no, I
to
totally do. You
decline
entered an
notice,
appearance.
and
I'll stop talking when I'm talking. With all due respect, you don't get the option to not show up, because everything you're talking about that's so important has to be represented in the moment, not after the fact. If anything, I made a decision without you here that you later complained about. And I didn't even know was going to be the grounds for a complaint. So understand, it's in the record, now it's from my mouth, that you don't have the option to not show up. Every call of the court means you're here, period. I'm going to remind you that I have the authority to make your life very difficult for not honoring that order. Because this is too important for you to opt in and opt out, to say when you think you're needed and when you're not needed, because these are big issues in my world that can't go unanswered at the moment. So if you're not here, you have a problem. Because this is so important, you don't get to opt in, opt out at your choice. Got it? There's nobody in this room has an option as a lawyer to show up or not.
Your Honor, respectfully, I disagree. I think that
Okay.
the decision that the contract that I signed with my client is for limited appearances.
That's fine.
We have
Just
3
need to-
attorneys for the entire state. We don't have any funding for me to sit in a month-long trial. I cover 13 plus counties for the state, so that's just unfeasible. I also have a family in Cincinnati, so.
It's a really good record to make. It's a really good record to make.
Yeah.
All of which I can't care about. Because what you just said applies to every other lawyer in the room. And me. At some point in time, our duty to the profession and to our clients exceeds our personal convenience and our staffing.
Not my family, no, Your Honor.
Okay, I mean, I get it. Good luck with work-life
My
balance.
client can waive my appearance, and he has. He agreed in that contract, and that was what the limited notice of appearance was filed for. My client has the right to do that. Me and my client have the right to contract my availability, but I think we're getting off track. I don't know that that's.
No, we're right on track. First of all, I'll tell you what I want to talk about, and then we'll stay on my track. And I respect your desire to have work-life balance, but the law is a jealous master. And we're going to get this right, because you showed up after the fact and complained about things I didn't do when you weren't here, and the whole second guessing can't happen moving forward. I'm giving you the privilege to ask me to reconsider a decision I already made. It's a privilege to hear it, because I want you to advocate. But you can't advocate after the fact again. I don't know where you live and have a clue about children and family. I'm happy for you. But work-life balance is like a mirage. It's totally mirage. Now you have to go talk to your management. But I brought this up and it's on my list to make it really clear. Like Mr. Collins not being here without explanation for trial, he knows better. He 100% knows better. Like if you want to have a limited representation agreement with your client, that's between you and your client. I got nothing in that, because I don't represent the interest of your client, you do.
Right.
And I'm not going to have second guessing after the fact with you gone. You're on record. You want to withdraw and your client wants to sign off, then that's a different deal. But a limited representation is not happening on this case in this instance. So I'm just going to tell you that I already ordered your appearance all the way through. Figure it out. We're not going to trial next week because we're stuck in the Court of Appeals. But when the case goes forward, the more lawyers, the better.
Your Honor, I'm going to assume that my client's going to have standing then, at this point.
Well, no, they don't have to have standing to be
I'm not
official.
sure I would represent their interests in this case if they don't have standing and I can't be heard anyway. So I guess I'm still waiting on a decision on standing prior to trial.
So if I say there's no standing for you to argue on behalf of the state, you're saying your client's no longer a victim?
I don't want standing to argue on behalf of the state. I want standing to assert my client's rights and any denial of those rights, which is the right to be heard when it comes to a change of venue that implicates their right to be present at the trial.
Let's go back and let you finish now on the merits.
Okay. So they have the right to be present. I don't know that there's any indication or objection that they do, but that comes from both the constitutional amendment and the revised code. And all appellate districts and the Supreme Court that have taken up the issue of a victim's right to be present for the entirety of the trial have issued in favor of victims being present. I was on the argument of their rights to be protected in a manner no less vigorously than the accused. Criminal Rule 43 requires that waiver from the defense. And, victims also have a right to be present for the entirety of trial, so they're the only person that should be able to waive that presence. The letters that you're going to take into consideration show the substantial hardship. It basically takes any choice out of the matter. This is a poor county. These are blue-collar workers. These are elderly individuals with health concerns. They cannot up and move their life for an entire month. They don't have the resources and it's just not feasible. So there is no opportunity for them to be present in another county, especially one like Cleveland or Columbus, which I think were counties that were identified by the defense in their original motion for change of venue. There is no supporting case law in Ohio currently on this issue because, as the court has already acknowledged, this is new. We're in a stage where the victims' rights are up and coming. They're just now getting to the appellate courts for interpretation after the Ohio Constitution went into effect in 2018. There is a very in-line case from New Jersey that I cited in my motion. It was a capital murder case. The victims claimed that they could not, the surviving parent victims of the child deceased victim, claimed that it would be an entirely too much of a hardship for them to go to and from a different county that would cost them about 2 hours on the road each day when they had other young children they cared for at home. And in that case specifically, the state and defense had originally argued a change of venue. The trial court had granted it, and then it reconsidered based on these statements. They were affidavits in that case that were submitted by the state on behalf of the victim. And the change of venue was reconsidered and moved back to the original site or county. So I think that specifically is in line with what we're asking this court to do here, and it's to consider the victim's hardships in the change of venue realm. Again, on that choice, I don't think there is one in the circumstance. There were, eight individuals who were murdered in this matter. That affects a lot of surviving victims. This trial, we already know, is going to be very lengthy, several weeks, probably at least a month, and it's just not feasible. There is no choice for these victims to up and move to a hotel room, to drive to and from. Some of them might not even have, reliable transportation to and from Columbus or Cuyahoga or wherever this matter ends up. So I do think that I know you asked about a 25-mile radius. I don't think there is a perfect answer, but I think that the further away, the more hardship that there would be for the victims in this matter.
So do I ask your clients for financial disclosure and affidavits of contingency? If I'm supposed to be exercising parity, competing victims' rights weighed in the same manner as the defendants' rights, do I not regularly ask defendants about their ability to afford a lawyer and make them fill out financial disclosure forms before I just make sure they have adequate representation? I mean, it's a hypothetical question, but like you just made a very important fundamental argument that's just proof with facts, void of anything other than conclusion. So do I make like TR, give me a financial disclosure form, list his assets and his liabilities, and I go through some comparison to federal income guidelines for a number of people in his household, the same way I would for a defendant?
Your Honor, I think we're comparing apples to oranges there. One, victims aren't parties to the case, and two, they don't have a right to.
If they're not a party, they don't have any right to argue a motion.
They do, under the Ohio Constitution and revised code section. They do have rights within the criminal proceedings, but they're not parties to the case. So they have privacy protections still.
Where's the privacy protection?
In Ohio Constitution, Article 1, Section 10. I don't have it off the top of my head, but they have a right to privacy in the revised code section. And under Criminal Rule 17C, any subpoena would have an opportunity for a motion to quash, and then if the whole Nixon test hearing, etc. They do have a constitutional right to privacy, though.
Why don't you send everybody an email, including me, with you articulating the authority for that? I'll take your word for it, but maybe that's not a good thing to do. I'm not really sure what I'm supposed to believe when people talk. Now, proper is one thing, But like you just made a fundamental argument that was conclusory. So I got to flesh this out. I don't ever ask a victim for financial disclosure,
Right, I don't.
but you just asserted economic hardship. And Mr. Hayes might not like the fact that I just assumed a fact that's not an issue. He might be fine with it. But I wouldn't ever let a defendant get a lawyer without signing an income affidavit saying he can't afford one.
Your Honor, I think this court has discretion to consider any hardship on the victims when it comes to implicating their right to be present in trial. I think the weight that you give that is, again, up to the court's discretion.
Keep going, thanks.
That's, I believe all I have at this point is that I just don't believe that there is any choice in this matter. The further this case moves away, the less likely there is any ability for these victims to show up daily, and they did in the co-defendant's trial. Even if those were half days and then they reported to work afterwards, they were able to be present. That makes a huge impact on the jury to see whether victims are in the courtroom. It also, with the live streaming, it assumes that not only the courtroom that this trial will be held in has strong internet accessibility and signal and all of the equipment necessary, but also assumes that each and every victim that would like to attend via live streaming has a smartphone, a tablet, a laptop, and also strong internet connection.
But if they didn't have transportation to the courthouse in downtown Waverly, is the court then supposed to send out an Uber driver?
No,
Or
Your Honor,
Lyft? What's the difference between, I gotta consider whether you have a valid driver's license and a car, as opposed to I have to consider whether they have a tablet and internet service? I get what you're saying. I'm just trying to understand the scope. Like, you're supposed to be the expert in victims advocacy. So I get the benefit of going to school on you. So if I'm supposed to consider their internet accessibility, is that any different than me having to hear an argument next month that somebody doesn't have a driver's license and the court owes them the legal obligation to send out a chauffeur driver every day?
No, Your Honor. Again, I think that's apples and oranges. This court made a determination that live streaming was sufficient to uphold their rights. He then instructed us to file on the briefing schedule to be heard on the issue, and I'm telling you that these are general concerns based on the decision that was made specifically. No victim is asking this court to afford them an Uber. Again, they're not a party to the case, and they don't even have the right to appointed counsel. So I don't think this court has any financial obligation to them, but it does have a legal obligation to uphold their constitutional and statutory rights. And so that's where that right to be heard comes in. And I think, again, there's a difference between a victim being expected to assert their rights in the county where the crime was committed. And again, that choice was made by the defendants, not the victim. The victim doesn't have any choice in participating in this criminal justice system. They didn't choose for these crimes to happen in Pike County. The defendant chose for the crimes to happen in Pike County, and therefore the defendant should answer to a jury of his peers in Pike County if that is a possibility.
Well, I'm a former crafty prosecutor, and Miss Canepa could have picked a different county. So in fact, the state picked the venue based upon the facts available and did a logical, fine job of it. It's not just like because an element happened here, you have to have it. She could have picked a different venue. We're dealing with the fact that that's her judgment. And it's her judgment. So like if there's heartburn about location, maybe it's just systemic.
Your Honor, I think generally speaking, the crime is usually tried in the county where the crime was committed.
Yeah, but one of these crimes was committed in Scioto. So what are we doing in Pike? Her judgment, logical,
Yes.
educated, wise judgment. But her judgment nonetheless.
And I think the argument there would be that Scioto County is about 30 minutes away. And Cuyahoga County is not. So I think a big part of this is unknown, how big of a hardship there will be until the actual venue is disclosed. But I think the point of this hearing today is to make sure that the victims are able to express the hardship that each venue would have on them. And if you take that into consideration and believe, that the venue should be Scioto County, then maybe in that circumstance, they are able to attend. That's not something that I can speak to on their behalf at this point. I'm just saying that the distance is, the more distance, the more hardship. And I think that's what their statements speak to.
But this is fascinating argument because a whole lot of people want to know how this plays out. It's less inconvenience and equal participation, in my perspective, when I live stream everything that happens in downtown Waverly to your house. So you can do childcare in your house without a car. And my accommodation, in fact, gave less inconvenience to the public and victims in particular. So now it's a question of perspective as much as anything else. And I live streamed for years.
Your Honor, in perspective to that, Jake and Angela, who are the key witnesses, and were in George Moore's trial, declined to be recorded and videotaped. So there was a whole week of testimony that if the victims hadn't been here in person, would not have seen. And I think that's major. That's a huge consideration to make when it comes to live streaming and the convenience of it. I don't know that there is convenience if they're still missing out on the main witnesses testifying.
Like, I'm just trying to tell you that there's easier ways to do it than being there. Like, I've conducted remote trials where no witnesses are here and half the lawyers are. And everybody agreed that that was more convenient and more accessible than thinking you have to be in a physical space designated courtroom.
Your Honor, I don't disagree. And I think, live streaming and everything that came out of COVID and all the remote appearances and stuff are a double-edged sword, because a huge part of the defense's argument is the publicity of this case. And that's why it needs to be changed. But if we're arguing that everybody has access to internet and Peacock and Google, then I don't know what a change in venue does in this particular circumstance either.
How about this? Your dilemma is my dilemma. You're going to be wherever I am for the length of the trial. Unless, of course, I allow you to participate remotely and give you a live stream to your house in Cincinnati. So which one's the harm?
It depends upon the individual, and that's why the victims.
So it's the victim's decision?
No, Your Honor. The victims' voices should be considered.
Yeah,
It's not. They have a voice, not a veto. I would never say that victims' rights are, elite to the U.S. Constitution. I don't think I would have any credibility.
Well, go with the Ohio Constitution, because that's what we're talking about. Ohio constitutional rights for a defendant stacked up against Ohio constitutional rights for a victim.
That's a discretional weighing that this court has.
I'll try not to screw that up again, if in fact you think I did the first time.
Your Honor, I wasn't here. I was just.
Which is the point I already made.
Yeah.
So like maybe I'll accommodate you and let you participate remotely, assuming you can waive that right.
Your
I'm
Honor,
very
these are
serious.
all questions that I don't have an answer to today, and I think depend on a lot of different circumstances.
Major understatement. You're right. Okay, so let's flip the switch, Mr. Hayes.
Judge, nobody's arguing that the victims don't have a right to be present. The victims can be present in the courtroom, the court doors aren't going to be shut. There's live streaming, the state can help facilitate some options in transportation if they needed to, but nobody's advocating that the victims don't have a right to be present. They do have a right to be present. In order for the victim to have standing, they must point to a specific right that has been violated. There's been no right that's been violated in this case. If this case proceeded federally, it would be tried in Columbus, You have jurors that have to be transported or find transportation from Ironton, from Portsmouth, come up for jury duty, and witnesses that have to come up there. These happen all the time. This advocate cited State v. I'm going to spell this, TIMMENDEQUAS. It's a New Jersey case, 737 AD 55. That case has no precedential value in Ohio. It involves a New Jersey statute. That statute constructed is broader than what was provided under the Ohio Constitution. It also discusses inconveniences to witnesses, inconveniences to the victim's family. That is broader than what is in Ohio statute. But at no point does the listed victims have the right to choose where the venue is, to choose where this case is going to be tried. We discussed, and I don't think I need to go through everything that was founded in this court's November ruling. The homicides that occurred in Pike County touched the heart and fabric of this community. It touched everybody. It's a small community. We've argued that. And if there is any example, any circumstances in Ohio, I've been practicing over 30 years, Mr. Collins has practiced longer than that. I can't think of where there would be another example for a change of venue in this case. Especially, this isn't the first trial. This would be the second trial in this county. But we've argued that, we discussed that, we talked about the saturation of the market and the individuals here. In reality, you know, if we started to do a trial here, would we try to push through it? Is that going to, you know, give us the right to a fair trial at that point in time? Then we have to step back and then reschedule and reevaluate our schedules and our dockets, and it would just be, you know, extremely difficult to do. There's no way we can have a fair trial in Pike County, you know. So I ask the court, and we'll incorporate our previous arguments, our previous motions to the court. You know, even the advocate recently stated, you know, we want the jurors to see, you know, the victim's family. You know, well, that you know, is an inconvenience. That's to try to change the balance of the scales here to give the state an advantage on that. So, Judge, we incorporate our other arguments. I ask the court to not have a change of venue. I think with this hearing, and I think even in our previous hearings, this court took into account the difficulty in listed families and victims in its decision. I don't think the court overlooked that. I think the court took that into consideration, even referenced it in consideration. I don't believe there's any abuse of any discretion of the court, and I can't picture another case that would have a harder argument for a change of venue than this case.
Thank you very much. Do you want to make any record, Ms. Kneppa?
If the court pleases, yes, I would like to. Your Honor, again, much like Mr. Hayes said, the court knows the state's position regarding change of venue. We trotted that out in the briefing, and we argued orally in front of this court, and the court, you know, considered all of that and made its decision regarding venue. However, I do believe that the victims' rights obviously were not fully represented at that time. While I did, in passing, make that comment about the hardship that would be not only to the victims, but to witnesses and et cetera, many of whom we did have to drive to court, as far as the witnesses. I do think this is new information. There's a reason why maybe the state shouldn't be representing the victims, because I'm not as educated and as proficient in all the victims' rights and the statutes and the case law surrounding their rights as Ms. Gall is. So I would ask the court, you know, I sincerely appreciate the opportunity for the victims to be fully heard today. And obviously she submitted statements on their behalf, but I would ask the court to not only fully hear them, but to also fully consider this in effect, you know, making a motion to reconsider its previous decision. And I recognize that the court will likely have to engage in somewhat of a balancing test or whatever, because the court has already found that the defendant's rights are implicated by not changing venue. So, you know, given the, you know, some of the constitutional sites, revised code sites, and case law sites that Ms. Gall has provided, specifically that the rights of the victim are to be, I'm trying to find, protected as zealously as protected in a manner no less vigorous than the rights afforded to the accused. I think that kind of changes the landscape. Now, again, what weight the court puts on it is obviously your discretion and the weight that you place on it. But I do think, given especially, of course, the state's position, that given that we used less than 1% of the jury pool last time for the county Pike, the factors in Skilling have only resolved in favor of the state in that there's been more passage of time. So you get more distance from Georgia's trial and Jake and Angela's things, but also recognizing that those facts are going to come into evidence in front of any jury. The fact that Jake pled guilty and what he has to say, that's going to be, as the court has recognized, key evidence in front of any jury that hears this. So whether or not a potential juror has heard tale of that, again, the court's admonishment that they, can only consider evidence that this court deems admissible into the courtroom, and not those outside sources. Surely Jake and Angela's testimony are going to come in evidence. So, et cetera. Those also were not televised, in the first trial. So again, I think the potential damage, there's U.S. Supreme Court cases that says even pervasive adversive publicity does not necessarily parlay into a presumption of prejudice, right? So we still have the opinion that the court should go through those cases and try to do a searching, careful one here, especially because of the victim's rights that absolutely need to be impacted, Your Honor, and adversely impacted to the point that some of them will not at all be able to attend hearings that they have a right to be present for. And there is a difference in televised, right? Because they can't converse with the prosecutor in between. They can't observe the jury. They can't observe the defendant. They can't hear statement of witnesses that elect not to be recorded and televised.
So does the prosecutor now, as a matter of law, have a duty to consider venue vis-a-vis victims? You had options with regard to venue. And in some cases, the options might be in a pattern of corrupt activity halfway across the state. So does that then put on the prosecutor, Mr. O'Brien's long-time career, to consider victims' availability to the courtroom when the prosecutor picks the venue? If you carry this out, is that what you're saying?
I think that would be a likely factor that you should consider. I mean, we certainly consider where the evidence is, where the witnesses are, where, because you want to be able to optimize your ability to effectively prosecute somebody.
Quality of the investigative agency, court facilities, all those, no, it's all baked in there. Let's just admit it. 100%. We look for effectiveness. We look for convenience. How many times have you shocked judges don't answer out loud? Right? We all do it. We all know it goes on. It's not wrong. I'm just trying to decide if now you're taking on another legal burden as the state's representative to consider victims' rights when you pick the convenient venue where you have a much better chance to obtain a prosecution. We all get shot. It's not wrong.
Yeah, I mean, again, how much weight that carries is at the end of the day, or, certainly not a single deciding factor, right? So I'm going to hear you say, yes, you now have to consider victims' interests when you select venue. That's my conclusion of what I just heard you say. Yeah. Okay, that's part of everything.
I agree with that.
In this case, the 3 of the 4 crime scenes are in Pike County, and at the time, we thought the 4th one was. And so it made most logical sense for Pike County. And that thankfully also aligned with the victims, because their family lived in Pike County as most of them did, not all of them did.
Given the oddity of the investigative resources available in Pike County at the time, it might have been better not to investigate this case here. That's just like a rhetorical question.
Yeah, I mean, ultimately, we need to as a prosecutor, I need to make sure that the judge is going to agree that venue was properly placed in whatever county we select.
But you don't lose the indictment, just lose the venue. But it was awkward, to say the least, when the local investigative agency wasn't like appropriate to be involved because of like third-party anomalies. You weren't there, I just heard about it.
Right.
Like, I look at most of the world from your chair. I only spent 3 years over there. I spent 14 years over there before I came over here for 27. All these perspectives are valid. Like, I'm not going to take on the duty to consider victims' rights if I'm a prosecutor when I select venue, until you all sit over there and yell at me for not considering something that you wouldn't want to consider either. I think if you had a choice to not have this case in Pike County at the time and gave it a tactical evaluation, you might have considered going to a different agency in a different county to try to get all the help that you couldn't get here because of the anomaly. You did a fine job with what cards you were dealt. So like, this is all argument, but people watch these arguments and want to know, like, some adjoining prosecutor is probably glad you picked here.
Oh, for sure.
Yeah, no doubt about it. Like, nobody
No, all the
asked,
counties that didn't get picked are happy.
nobody asked for this. You involved other counties with regard to investigations far flung to steer clear of the anomaly. If you thought you could have just landed in one county and not had to deal with the far flung, that would have been even easier for you.
Yeah, I would say convenience to the prosecutor is probably the last thing to be considered, however.
That's a really good public statement to make.
It's true.
That's subjective. What else you got?
I would also note, Your Honor, that the first trial was live streamed, and yet the victim still chose to be here, which I think is a very good sign to the court. The value that they place on that right to be present is they did have the ability and the convenience of just sitting at their house and watching this, but they chose to be here. And as this court knows, that was an extremely long trial. From when the evidence starts, it's 2.5 months of, testimony, not to mention the selection of the jury. So there's no question, Your Honor, even obviously Mr. Hayes agrees that they have a right to be present. I would agree that there is no substitute for being present. And while we appreciate the court's, thoughts on how to try to solve some of those issues, we submit that that's not sufficient to that they have this strong desire to be present, and that anything other than being able to be present. And I don't think that the court, I understand what the court's getting at, well, how do I know this is going to be a financial impact, and blah, 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 blah. Obviously they're not asking the court for court-appointed attorney or anything else that the court needs to make that assessment. I don't think it takes much more than common sense, though, to believe everything they've written in here, right? That, one of the victims talks about, he would come for half days, which is you're able to do if you live in the same county as the case is happening. And so just the ability to get back and forth to court, drop kids off at the bus and be there when they get off the bus and all that stuff, obviously is doable if it's in Pike County and not doable if it's much farther away than Pike County. So again, Your Honor, given the fact that the state does not believe that there's a presumption of prejudice, which then reverts back to this court at least trying to see the jury, coupled with the interests of the victim, which at least the Constitution says should be pursued as vigorously as the rights of the defendant, I would ask this court to reconsider its decision on venue, but again, as Judge Corbin did, without prejudice, so that if it appears insurmountable, this court still has the ability to change it.
I'm not going to run around the room again to let everybody rebut, so I'm going to move on. Maybe the rest of it goes a lot faster. I mean, honestly, Ms. Gall, this is what I wanted to hear, because you're the specialist. I had lawyers ask me one time why I would grind them so hard when I would rule in their favor. And I told them after the fact, I grinded them really hard because I wanted to see how good their argument really was. So if you thought I was grinding you, it doesn't imply that I'm opposed. It doesn't imply anything. Like Ms. Canepa coming at me, me going back at it, that's how we get better, right?
Yes, Your Honor.
So like, don't misunderstand body language or figure, whatever that means to you. On the list was also the question of severance. So we got to back up before that because there's a motion with regard to other acts, evidence, other acts. We argued this before. Memory serves me right. January, we had discussion. I think I gave 14 days and 14 days. And instead you made a compelling argument and gave me a list, if I remember right from my notes. But I didn't want to get to things if you still wanted to brief or be more specific. So I just want to close that book.
Thank you, Your Honor. We have researched the issue of severance, some case law on the issue. At this point in time, we're not planning on filing a motion for severance. There's a lot of interaction between that issue as well as 404B issues that we'll continue to object and raise issue to as proceedings go along. But at this time, we're not anticipating filing that motion.
Okay. I kept your list from the last time where you sort of gave me, these would be appropriate. Like I'm going to still have that in the notes because I was the one asking how this plays out because you're asking me for a really nicely wrapped, tightly defined other acts decision.
The basis, and the basis that I provided at the January date was founded in the 404B philosophy and the rules under that, under 404B, which we believe we'll be able to achieve our goals, our strategic goals, our legal goals through arguments under that rule and the case law under that rule. As far as filing the severance motion now, strategically and based on some research, not prepared to file that at this point in time.
Are you withdrawing the 404B motion?
No, Your Honor, we're not.
Okay, so I'm right back where I was. Because I brought up severance in the context of how do I give you this tightly defined, well-answered 404B decision? And it all depends on what the elements of the offenses are. Like, you don't have to change your position. I'm just saying I'm back where I was when I brought this up.
And I don't intend to change the position, although this is an ongoing, it's a motion in limine, the 404B motion. So this is something that will be continued to be evaluated and argued as we go based on what evidence is being presented or attempted to be presented. So that conversation will continue, but with regard to a severance motion, not anticipate filing that.
Thank you very much. Mr. Brian, you want to run this?
On that issue, Your Honor?
Yeah, on severance.
Well, I think as long as they haven't filed a motion and don't intend to file a motion, I have nothing to add.
Yeah, but I asked for it, which I'm allowed to do. So the criminal rule 14, the context is they want me to say what's admissible testimony with regard to other acts, and other acts immediately implicates what the charges are and relevance. So like they get put together. They're
at least my thought is, Judge, that other acts will come in whether or not there's a severance or not, because of the ongoing conspiracy that occurred, and therefore they would be admissible under 404B, whether or not there's a severance.
Okay. Now, am I supposed to let Ms. Gall argue on behalf of Criminal Rule 14?
I don't believe so, Your Honor.
Why not?
Because she's in here for the victims, not a party. That's an issue related to the issue of severance and or 404B.
What do you think, Ms. Gall?
Your Honor, I am not educated on this notion to sever.
There wasn't questions whether you have
It's not something that I plan to weigh in on. I think that this doesn't implicate a victim's rights. Victims don't have a right to present evidence at trial or try the case.
Okay. Another run at it? Anybody? Mr. Hayes, you're good. Okay. We need to talk about scheduling, which we can do off the record. Because it's still set for May 30th. How about, just for my benefit, an update on where we are in the Court of Appeals?
Yeah,
Mr.
fine.
Collins?
May I?
We're still
Yeah.
on, right?
Yes.
Yes, yeah. We're still on this issue.
May it please the court,
Thank you.
Your Honor, I believe they picked the final oral hearing date of June the 12th. That was agreed to, I believe, by the government's appellate attorneys and our other co-counsel, Mr. Goddard. And I asked Mr. Goddard in terms of, in this type of appeal and this type of urgency, what he believes the result would be. He believes there'll be a decision in 30 or 60 days, but he qualified that by saying, however, I'm usually wrong on those things. So, but because of the nature of this appeal and the urgency of this case that the court has put on there, but yeah, the oral arguments are June the 12th. He believed the decision would be made within 30 to 60 days.
If I might address that, Your Honor,
Yeah.
I'll take it over on that.
But then, the over, Your Honor, depending on them, what happens is if they rule in our favor, I'm sure they're going to appeal to the Supreme Court, vice versa, I'm not sure. But, and then again, with the victim's right advocate, who knows in terms of what gets appealed there. So, but just the basic information, June 12th of the oral arguments, and hopefully a decision will be within 60 days.
So this court doesn't make available documents online. So it's hard for me to snoop or actually find out what legal issues are going up. All the assignments have ever started out, the trial court aired. I'm good with that. It's just how we do it. So in the interest of not airing, I was trying to figure out whether anybody argued invited error, which always circles me back to the dilemma between where you sit and where I listen. So was that even briefed?
I don't believe so.
Briefed, you know?
I don't believe so, Your Honor.
Like, don't take this personally. Like, I like lawyers, maybe because I are one. And we think alike or we're trained alike. And I tend to believe what you say. But I'm getting hoisted on the Court of Appeals pewtered for doing what you said you were going to do, which I consider to be like invited error. Now, I'm okay if they don't consider that invited error. I'm 100% good with knowing what the Court of Appeals says because I follow what they say. But moving forward, I always have the ethical dilemma, professional dilemma of whether anything you just said for the last hour and a half is anything I should believe. Nothing personal. We do it all the time. Our professional representations, our character, our ethics have meaning, hopefully value. You know, I heard you say, Ms. Anstead, that at the moment you don't have a motion to sever. And previously you answered my question about what could be a place to sever. And you're walking it back, but you could resurrect it later. I get motions in limine. You didn't do anything wrong. But if I'm supposed to be driving the bus and have some idea of where we're supposed to be going, Like, you don't have to like it, but I pick the direction because I get stuck with the trial court erred. If I drive the bus or if you drive the bus, it's always I erred. So like I'm more proactive, strike that, engage, no, attentive to where the bus ought to go. And I will continue to do that because in the end, we got to be ready. And Mr. O'Brien might be right on the over. Not a betting man, but that's a pretty prudent wager, perspective, or whatever. They got more than one case too. And so does most of the lawyers in the room. So I will wrestle with the professional dilemma of believing what I hear. Anything else on anybody's list?
Yeah, just two minor things to update the court. First is with regards to our client's hearing deficiency. Through his family member, we bought a device that we thought would cure that. It did not. I then met with an audiologist in Columbus, Ohio, explained the product, explained what was going on, and then called the Pickaway County Jail, both the medical department as well as administration. They don't have someone who regularly will assess hearing, but through Ohio State has a program that goes into prisons on a regular basis in some jails. And I was able to obtain a person, an audiologist, who will go in on May 7th, as long as I'm there, to have the hearing check. To give the court an update, it's probably about $6,000 to $8,000 for the hearing device that the audiologist thinks would probably be necessary along with a microphone. So I want to make the court aware of that. And then Pickaway County indicated that as long as one of the three of us was with them, that they would accommodate the best they could in that assessment. Normally they send the people out to be assessed at a different place, but they didn't seem inclined to want to do that in this case. So I believe the Ohio State audiologist will go on May the 7th.
So you're saying it's an employee of Department of Rehabilitation and Corrections?
It's an employee associated with Ohio State, and they
Ohio State University.
Yes, Ohio State University has a clinic that provides this service to county jails as well as to prisons, I believe, as well. So they have some type of relationship with that. That's as far as I've made it. The audiologist I was initially working with works with the veterans, and they contacted the Ohio State individual and said that yes, they've done that before, and they would not have a problem doing it. So,
are you aware of this issue, Ms. Knapp?
I mean, Mr. Collins, brought it to us, our attention. He's been very upfront. And I know the court said you might make some inquiries. And I guess it's the responsibility of the jail to provide medical. I mean, the bottom line is, speaking of indigency, his family is not poor.
It's not.
Could be accused of being millionaires.
He is.
Family is not the test.
He is.
Well, carry this out, because now do I have to get an affidavit of indigency from the victim's family?
Well, only.
No, I get what you're saying.
The only reason I said that is because Mr. Collins made a comment, I think, in his email that he couldn't find a family member that would finance this.
Yeah, no, I don't.
So,
His family's got nothing to do with it. They got no legal obligation.
I think when he's in custody, I think the jail is responsible.
Yeah. So here's my answer, because I did what I told you to do.
Right.
Nobody that works in jail thinks he's got a problem. No. So you can do what you want to do, and I'm happy you're proactive. Like, I totally like this. But at some point in time, the question's going to come down as like a convenience or a necessity, right? Like, from a practical standpoint, nobody there has ever experienced, charted any hearing deficiency. So in their world, they're a little skeptical.
Understood. Just for the court's background, from the day we first met him, it's always been an issue on one side. I came here, he returned, and we had to talk about it. And then the second is to update the court. We had a very productive meeting at my office with Mr. O'Brien and Ms. Canepa. I think we've narrowed down potential stipulations and probably cut out 30 or 40 witnesses who might not be necessary. I would only ask, the government was going to provide us with those, we would like to try to get them in writing, and then to make sure our client signs off on those. We are in the process of doing that as well, but that was productive in terms of, I think we cut out 30 or 40 witnesses, correct? Stipulations, right? So just update the court on that as well.
Music to my ears, or at least one ear. Anything else?
No, you're right.
Thank you. From the state, Ms. Gall, anything? Okay, so let's go off the record, find dates, scratch our heads. Thank you, Joe.
Thank you.
You're welcome. I think I'm just gonna write them down, and then I'll put an entry on, so we don't have.
Right. So sorry, I'm turning all off all the boosters that I had on on the sound. So when I come on, I'm not yelling in your ear. So we are just trying to like figure out if they are going to come back or not. I don't know. I have absolutely no clue if they are going to come back. So we do have the couple of things that I want to get done. There is no information and nothing so far from our courtroom, from our verdict watch. But I mean, we can pick a county in Colorado and just watch some hearings like we did yesterday, and hopefully we'll have a hearing soon. There is something else that I want to do, but I need Zio for that, so I think we're gonna wait for her. Um, Sorry, in 1 second. I just need to text her to see if she was like coming or not. So until then, we're just gonna carry on hanging out here to see what's going on. When I work at this one house, I had to be at work 5 a.m. It was like the thing is, I don't mind a 5 a.m. start. I start at 5 a.m. every day, and I finish at 11:15 in my time, which allows me to do this YouTube thing, which I do on my spare time, which is almost every single afternoon. But I have very long days, and doing both is getting to a point that it's getting me tired, very very tired in need of doing, and I might have to choose which one I would do, obviously. Uh waking up at 4 a.m. because I wake up about what 4:15 to get to work. For 5, I work 4 minutes away from the store. I work in a supermarket. I work in a bakery, in a supermarket, and that's what I do on my not on my spare time. I do this on my spare time, the YouTube thing. So yeah, but waking up at 4 a.m. I am over it. It's hard, especially when we were covering Laurie. I was finishing at 1 o'clock in the morning, go to bed for a couple of hours, and then go to work, and then come home, sleep a little bit or take a nap or something, and then stream again. So it was crazy indeed. But it was worth it. I would love to cover that trial. It was absolutely a pleasure to do it. Um, so yeah. Um, so what I was we're gonna wait for Zio, but she gave him the green light. Um, Yeah, that's the thing. I have the same thing, Kara. I naturally wake up as well at like 3, half 3, 4 o'clock. I can't sleep past like what 5 a.m., 6 a.m. top. 6 a.m. it's a lay-in for me. So I am annoyed. I don't like it. I want to slip in, but yeah, my body was just like, "Bing, wake up, good morning." Um, so thank you very much, Zio. So there is this sentencing that happened yesterday, right? That our friend Zio told me about it. And you guys know me. I am a true crime addict. I have an issue that anything that people tell me, a case or hearing or a trial, my interest picks, and I want to watch it. I want to know what's going on. And so there was this sadly incident in Walmart in Texas, where this guy he pled guilty apparently, and his sentence was yesterday. So I was gonna cover it with Zio, but she isn't available right now, which is okay because real life stuff it's more important than YouTube. And I hope you enjoy your day with your family, and a happy birthday to you, Nana. Um, so I was gonna say we can watch it together while we're still on Verdict Watch, because the feed of Billy Wagner just went off. I don't think they are gonna come back. They are gonna talk about the scheduling. I'm gonna keep an eye on the on this case, so we know when it's gonna go to court, so then we can follow it and maybe follow it. The thing is, I don't like long trials. I have a thing that I don't know if it is ADHD or if it is lack of concentration. I cannot concentrate on trials for too long. My my attention span, it's like a week trial. A week trial is perfect for me. So that's my um my limit, I guess. So a month trial for me is it's a bit much. So okay, so I'm trying to look for the videos um that Hio sent us about this. Um, I know squirrel. I like literally. I'm like, huh, squirrel. And then the thing is, if I get a lot of notifications, right, it's even worse because I would start reading the notification, and then I'm like reading, and I forget that I'm like either talking to you guys or doing something. And I am the same thing at work. I have to be having to listen to music because otherwise my mind is just gonna wander outside of work and then will never return to work. And it's absolutely it's yeah. So I think I need to go to the doctors for that, to make sure that yeah, I don't have the ADHD, because I'm literally just all the time I'm jumping up and around. Um but yeah, so we oh wow, okay, I think that's the full hearing actually. Hang on. So oh wow. Okay, hang on. That huh? Hang on. I'm trying to set up that sentencing thing, but it like literally I can't hear anything. Or is it my headphone? Hang on. Yeah, no. No, I can't hear. Uh oh, I need your help. Oh, okay. This is audio. Oh, okay. Right, okay. Either right, sorry, hang on. I'm getting instructions of what's going on because I'm lost as always. I saw a squirrel and got confused and gone. Fast forward. I am fast forwarding and it has like literally nothing. I can't hear a thing. Like the audio is on, so I can't hear the one that is like 8 hours. I can't hear anything. Let me reload this because I can't hear a thing, and I'm like, what's going on? Um, let me try another one to see if I. Okay, that one does work. Okay, my sound works, so it's not my sound. Um, so I didn't like. Oh, okay, that is the audio only. Let's try the audio only. Right. Okay. uh, Okay. So oh yeah, Zio is great. She is amazing. Absolutely. Sorry. Um yeah, Zio, please help. I am having I don't speak English anymore. I want to quit speaking English sometimes. You know. Um so yeah. So okay. So I think Hello. Yes, we've made it. Ay, vamos. Buenos dias, my friend. Hello. Oh, Zio is here. She's gonna help us. Hello?
Hello, are you okay?
No, help. I'm okay.
You're broken.
I'm
Oh,
broken.
goodness. Okay, just a second.
Look at me. I'm a professional streamer. I know what I'm doing. No, I'm not.
I'm going to put the one that you need to play in the back chat, so you have that, and we'll start there.
We'll be going to the back chat, everybody.
Back chat. Okay. Click on that and bring that up.
Bring that up. Okay, hang on. So this one, which one is this one? Oh, okay. Ow, ow, ow. Sorry. I had a little bit too loud. Yeah, that one the audio plays, but the one that you sent me, the 8-hour one, it doesn't play any sound whatsoever.
I'll get it keyed up and I'll tell you where at what time you need to start it. Okay?
Okie dokie. Artichoke.
Carry on.
Carry on with what? What?
Are you gonna put it up there so people can see it?
I don't know. I'm lost.
You've got it right on the screen. Play it.
I haven't. Is that my screen or is it your screen?
That's your screen.
Okay, no, it's not this tab. Why do I have two tabs with the same video open?
See, bless me. Thank you.
Yes, bless you. Yes.
Ahí vamos, ¿cómo estás? Ha sido un mes desde que te vi.
It has been a month that you've seen her.
I think so, almost.
Like, do not speaking Spanish with me, because I do speak it too.
That's okay.
You have to find a language that I don't speak, so you can speak it. Oh man, we are wilder than the courtroom that from this morning, man. That judge, it's
Right.
something else.
So did you talk a little bit about what the case was and what the issue was?
Yeah, I said there was a Texas man that opened fire in a Walmart, and now it's the sentence because he pled guilty.
He did. He looks like a lovely, friendly guy, doesn't he?
Oh yeah, he looks very friendly. Zizi, what's going on? I'm getting help from Zio because I'm absolutely lost. ¿Qué te pasa? ¿Qué te pasa? Like, yeah, Katya squirrels, and so exactly Katya squirrels. So Zio came to help. Absolutely. So it's just because
Cara.
the county Pike hearing is finished. And we still don't have a verdict. So we are moving on to the next, not next best thing, but the next thing that we have while we are on verdict watch.
Look,
which I'm
professionals in the industry call this impromptu.
Exactly. So we're trying to find things to watch. But yeah. No news on Joseph Anna. I'm getting a bit scared, man. I'm not gonna lie. I'm getting scared that they haven't been on screen yet today. So I'm a little bit scared. So well, you can just see me speak another language and be lost, I guess. I don't know. Now I'm still gonna speak English. I mean, I barely do speak it, but I'll still carry on speak it. I'm pretty sure that's not what it's called. What is not called? I don't know. I have no clue. I don't speak English. Yeah, he is guilty. Yeah, but I hope they come.
Well, then we don't need to watch it because Galen May already said he's guilty. That's it.
Yeah, exactly. We don't even need to watch. Of course.
Thank you for the verdict.
Thank you for the verdict. That's our verdict. Exactly, indeed.
So the second part of this, so this one right here is 30 minutes, and this is the actual. So he pled guilty, and he is going to be sentenced to life in prison. And the biggest part of this is that when you automatically plea, a lot of times they don't, especially this guy, doesn't want to hear from the victims. So the bigger part of this case right here was the victim impact statements, which have been the last 2 days that they've gone through. It's been a lot of impact statements and victim impact statements in this case because none of them got to say their piece, basically, is the long and short of it. So he pled guilty to all of the state's charges. He was the Walmart shooter from El Paso, Texas, and so yeah, there's that.
Okay, that sounds like a great backstory, and that's all we need. Um, um, I do. I'm just lost today. I'm in a squall moment. I think that energy drink is making the opposite effect of waking me up and giving me energy. It's actually giving like a key energy. That I don't speak English, so I'm just like squirrel moment.
So
I was
the
like the
other
sorry, you
part
go.
in the no, you're fine. The other part in the back chat, what I'm leaving you is the victim impact statements. If you get to that, at parts and times, because they're shining the visual at the wall, it's not very appealing, but they don't show the victims' faces in
Yeah.
that. So it's an hour and 46 minutes. So if you're still looking for something or you don't have any parole hearings or anything to look forward to, then you have that option as well. And I'll just leave that in the back chat for you. Okay.
Yeah, okay, thank you. Appreciated that. But and I did have a quick listen to that one, and yeah, I was scrolling through, and one of them is in Spanish even.
Yes,
I
they have a translator. So in each
Yeah.
one of them, they have a translator.
So Hannah is asking, did he avoid the DP by pleading? I think
No,
so.
no, he
No?
didn't. No,
Oh,
or there wasn't, they didn't even have the death penalty on the table. I think this is just the life in prison. I don't think there was
okay.
an option for the,
Okay. All right. I think what we're gonna do is watch the half an hour one, then see how we are with our trial. Because the thing is, I feel bad for the victims and I respect the victims and everything, but victim impact statements are um so hard to hear, and it's just a very emotional time, and I don't really want to cry anymore today. I think I've cried enough for today, but we'll see what we want to do. Because we're gonna have another sentencing tonight, so two sentencings in one day, two like it might be, but we'll see what we do. I mean, I might have a squirrel moment and do it after all. But yeah, thank you very much for that, Hio. Appreciate it.
you're welcome. Yeah,
Um
23 life sentences. That's why they didn't put the death penalty on the table. We do have the death penalty in Texas. Trust me,
oh
we
yeah,
do.
I know you
But
guys just had one
yeah,
going.
just this particular case was not one of them.
Yeah, well,
I forget
it's
I'm typing as you. I'm like typing as you up there. I'm like, oh, I'm TCA today.
yeah, no, I can see that. I'm like, I'm not typing. I keep forgetting that you can do it.
Well, skip the victim impact statements if you want to, and then do this, and I will jump down and be listening in the chat. Yeah, the lady
I
behind him, she looks sketchy too, right?
know. I know. Um, I don't know. It's
So,
this
Cara,
case. Yeah.
we were talking about this. Another friend and I were talking about this yesterday. So the actual things that they inject, the lethal injection things, they go out of date. And apparently the last of what was made in Texas went out in 2023, but we've had a couple of different lethal injections since 2023. I don't know how many. I'd have to look that up factually. So I'm wondering with the out of date, stuff like how we're getting away with that. I don't know. I'm not going to put it out there that they're doing something wrong, but I'm kind of curious about that, which is part of the reason that Idaho is going firing squad because they have the same issue. There wasn't,
Wow.
yeah, they don't have the injections for the lethal injections. So I find that
Mm,
interesting as well.
yeah, I think Sissy might be correct. He must have something wrong with him because otherwise, I think they would have done it the DP to him. But I don't know.
Well, I
But
can name a lot of things wrong with this man.
well,
He
yeah,
did
true.
walk into a Walmart and start shooting people with a
Uh,
you know,
yeah, I think Hannah's panicking because there's two TCAs. So I think she's
dun,
panicking.
dun, dun.
She's guilty of panicking. Sorry. I know I'm trying to be funny. Emphasis on trying. Yeah, Idaho has the fire squad thanks to BK. Yeah. And I think Luigi has an arraignment today as well. Luigi Mantione for the DP now that is facing. So that case is not going to be
Okay.
televised. Okay. All right.
Don't do it
carry
yet.
on.
Don't do it yet. I'm gonna show you something. Okay. We'll do this
uh-oh.
because it'll take just a second, and then you'll understand where I'm coming from. I want everybody who's not in a good mental space to take the 3.5 minutes to go do your bathroom and break and all that kind of stuff. So anybody who's not in a space where they can watch this
It's
needs
just a
to walk
content
right out.
warning. Yeah.
Yeah. All right. Here we go.
This morning, new details from the massacre in El Paso. First 911 calls came in at 10:39 a.m. Saturday. An active shooter on the loose, terrorizing families shopping at back-to-school sales. These chilling images captured the gunman on Walmart surveillance cameras, wearing ear protection and carrying an AK-47 style rifle. Frantic shoppers rushed out of the Cielo Vista Mall and the Walmart Supercenter next door, where bodies were lying outside. Stores went into lockdown. This JCPenney employee began directing people to safety.
He's coming from this side. You guys have to run down.
The shooter's that way?
He's over here in the other.
Paralyzed by fear, others hiding under furniture. 10:45 a.m., 6 minutes after those first 911 calls, first responders were on scene, securing the area. 11:06 a.m., the suspect, 21-year-old Patrick Crucius, was arrested. Police say he surrendered without incident and was the lone gunman. Investigators say hate may have been the motive. In all, at least 20 people were killed, dozens more injured. The victims range in age from 2 to 82 years old. The wounded, bloodied and dazed, were triaged at the scene, some using shopping carts to transport victims. Survivors shared their terrifying tales.
The shots were going, do, 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 do. And then he was like, is that gunshots? I said, yes. People were running inside saying there was a shooter. I've never been so scared in my life.
In the chaos, Glenn Oakley tried to scoop up several kids that got separated from their parents.
I'm in the military, so when I hear gunshots, I just think take cover, save whoever I can. But I was just so worried about those kids, man.
Hundreds answered the city's calls for blood donations. Lines stretched for blocks. Upon hearing the news, Democratic presidential candidate and former El Paso Congressman Beto O'Rourke struggled to contain his emotion.
I'm incredibly saddened, and it is very hard to think about this.
A local school was set up as a reunification site, but hours later, people were still looking for loved ones.
All I want to do is find my mom. Somebody needs to tell me where she is. I want to know if she's dead or alive, or if she's still in.
Overnight,
one
as the
second.
city of El Paso.
The courtroom that we are following, the thing just went live. The verdict. I don't know if there's a verdict, but the thank you for putting that up. But the courtroom that we've been following just literally just went live. So I don't know if it is verdict. I don't know. Sorry, the interruption, guys. But like I said, this one we have to follow it live. We cannot pause it. So yeah. So I don't know if it is verdict. We don't know. It might be. It could be. I'm always in a ball. I'm refreshing this every like 5 seconds. Literally every 5 seconds I'm refreshing. It's like, please go online, and they just did. But yeah, thank you for that. Yeah, I think it is going to be a verdict. So I think I can jump the gun, and hopefully this is not too loud. Hopefully it is not too loud. So here we go. I'm gonna play it. All right, I'm playing the verdict music because I like it and I like jumping the gun. Oh, Theo, you went. Oh no, I'm sorry. I didn't even say goodbye to Theo. Oh, Theo, bye. Yes, Colorado is the state that we have the soothing voices. Absolutely, I love it. I could fall asleep. Oh, hi, good morning, Stevens. Yes, I liked following like the small little cases. It's very fun and everyone uh everyone is covering KR, and it's just yeah, covering KR. I like covering this small little cases and hearings and sentencings and doing normal stuff. Um you were in chat. Oh, okay. Nice to see you, girl. From there, I am. Why am I doing the heart thing? You can't see me sadly because I have the camera off. Oh, oh yeah, because the actor of ER, Noah Weil. He is doing a new show that I've been literally hooked on and obsessed with. So yeah, that's why I was talking about ER. Yes, we are back on the courtroom of the no speaker, Kara, and thank you very much for that short. That was absolutely hilarious. I really, really appreciate that. Thank you very much. I did see that, Paula. I really, really appreciate that. You are amazing, and I appreciate your help and doing that. I really, really do. Yes, he is guilty. Hopefully, they will find him guilty. And here we go. I'm so excited. I'm so excited. Um, yeah, it's gonna be a verdict. We have a verdict. I think it is because like literally look at the bailiffs. You said it earlier, and the bailiffs that they are gathering all around. It's just absolutely crazy. So yes, we have a verdict. They did not take too long. I think yesterday they were already had the verdict, and then they maybe just like filling paperwork today, and yeah, they were there the whole trial. What, the bailiffs or everything? I don't know, maybe, but still, um, yeah. I definitely needed a good laugh, and I appreciate that so much. But the thing is, I think if it is found guilty, we're gonna have the penalty phase. So, I absolutely agree. I absolutely agree. Um, I agree that as well. I agree with everyone. No, is because I think this morning was just filing paperwork, was just making sure that everything was filled because I think people are coming back now in court, either a verdict or a question, but I don't think so. They have a question. I don't know. We only followed somewhat of this trial, which I am a bit upset that we did not follow more. But it's okay. We live in a learn, and we'll keep an eye on Ohio or Colorado cases because we have this method to be able to follow more Colorado cases when we have a bit of a break. And we can use that to our advantage and cover trials that also need to be covered. So I really like, and there's another case out of Colorado, but I don't know what's going on. I need to try to find some information about that case. Oh, I think here comes the prosecution team. Look at that, they are arriving in court. Um, so like I was saying, there's a case out from Colorado, and I need to find more information about that case, but I cannot find anything because I think they put her as a juvenile and she's not a juvenile. So, but the case also includes us over here in England. She did the crime in Colorado where she resided. Kimberly Singler, I think that's it. I will put in the chat Kimberly Singler. I think it's from El Paso County, and she did what she did, but then she ran away to London in the UK, and a judge in the UK put her out of the UK back to Colorado for her to face charges. She literally went to court in the magistrates court in England, had hearings, and they because they we don't live stream hearings or anything from the UK, but there was press involved in that hearing. So they yeah, that's how I know about that case. So they exactly, they literally put it out. So the prosecutor Leticia Strauss, what? That's the thing, Hannah. I don't know if she has been deported yet because I can't find any information, nor either in England I can find information about her, or in Colorado system. Because I would imagine if she's being deported from the UK to US, back to the US, um, and she's been under arrest all this time, she was going to go to jail, right? I can't find it in any jail in Colorado. So I can't find it. The only case I can find under that name, it's a juvenile case. So I like I need to find that case because I'm obsessed with that case and I want to follow it. For trials, I mean, I think it is from El Paso. So let me have a look. I have on my spread, one of my spreadsheets I have okay, here. I'm just opening up. Bear with me a moment. So is which case I scrolled. um, so that's where is she? Yeah. Uh, yes, for District 4th El Paso, exactly. Ooh, excuse me, I'm correct. So yeah. Um. Oh wow. SS Stevens, I'm so sorry that this happened 30 minutes from my town on roads my family drives all the time. It's made me physically sick to hear about what these idiots were doing. The only reasonable outcome is life without the possibility of parole. I agree. Absolutely. And I am, all my days, it's crazy and it's insane that that happened so close to you. Um, I'm glad that you and your family are a little bit safer. Hopefully he's gonna get found guilty, that this is not gonna happen anymore, and I am so sorry about that. um yeah, it's Colorado Springs, so El Paso. Yes, okay. Um, and we agree that you should get life without the possibility of parole. Absolutely, agreed. And we hope that justice is for Alexa and for all the other victims involved in this case, because it was not just Alexa, because he's facing 19 counts on this thing. So yeah. Um, Indeed, guilty. So, well, like, let me, yeah, make sure that it's on. Uh, yep, that is one. Back in January, a court in London, that was Westminster Magistrates Court, that Singler could be sent back to Colorado. But Thursday morning, we learned that Singler's attorney has appealed that decision in March. Yes, that was a couple months ago, and since we haven't had any more information about that case. So that case that I found under Kimberly Singlet on, and so yeah, no more delays and only one appeal. No appeals. The end. No, just verdict, gum, and like she's found a pothole. Lol. Yeah. Oh, she's not in Colorado yet. Oh man, I'm gonna have to go to London to try to find her. The thing is, here in the UK, it's very hard to get any information out of court systems. I tried to call this court house, the magistrates court in London, where the hearings was, and literally. Because I'm not a media part of the media, they won't release any information. So um I know. So it's going to be taking a while. Of how far is London from me? I am about 4 hours away from of driving from London. Um, in 4 hours I can be in London, so it's a little bit far. I think it's about 4 or 5 hours, so it's not bad. It's quite reasonable. Um, it's a good drive. So let's go to London. Yes, I need to go to London. I need to visit my friends. I have friends down in London and the area I used to live before. Um, I I need to go visit them, but life has been busy and crazy, so I have not had particularly the time for to go to there. But yeah, but I'm planning to go maybe in the summer, but towards the end of the summer when garden pot is a little bit less busy, because right now he's like super busy with work. He's literally, it's 5:30 in the afternoon right now, over here in the UK, and he's still not back from work, and he's been at work since about 7 a.m. this morning. So it's the highest season for him right now, so it's a bit hard sometimes to. Oh yeah, he's the garden guru. Absolutely. He did came home for lunch, but that was just for lunch for like half an hour lunch, and then he went back out. And he is a very like very OCD when he's doing gardens and everything. So it's just he's very good. I'm very proud of him. He does a very good job. Um so yeah, so we're just waiting on a possible verdict. Oh yeah, he does, he works very hard, no, like either at home or outside of the home. He does work very hard, and he takes very good care of me. I have to give him that, and he cooks very well too. But we are spoiling ourselves today with a takeaway, with some food, because we deserve it. It's celebration of surviving this crazy week that has been. So yeah, and actually need, because I can track him. You know that app Life 360. We both have that app, so I can track him to see where he is. Was I supposed to show? I am so sorry. I did show Garden Bot. I did show Garden Bot. I'm so sorry. I'm sorry, Zizzy. I did not know if I could show. I normally don't show things if unless I'm specified that I could show. Kara, Crazy Week doesn't even begin to describe. I know, but I think it's. I am laughing right now, but I don't want to laugh. This week, that's. Let's not talk about this because I don't want to cry anymore. I have cried. I've cried already way too much, indeed. So, oh, okay. I am so sorry. Um, I'm sorry. I apologize for that, Zizi. My apologies. Yeah. So definitely this week has been wild. I definitely need We're part of I am near Newcastle, Sunderland, Newcastle area, around that area, and that's where I am right now. Yes, Denise, it's a verdict. We did post on Discord and Facebook. Yes, it's we're assuming there's a verdict. I did play the verdict song and everything, and I'm thinking, ooh, the judge is here, the judge is here, the judge is here. Ooh, nice. Just watch a lawyer knows big thing. Yeah, it's thinking for justice indeed. It's not gonna get it any other way. But so we made it.
Good morning, 23 CR 1034, People versus Joseph Koenig. Entries of appearance.
Catherine Decker and Bryn Chase for the People, with investigator Dan Manka and our paralegal Leticia Moda.
Good morning.
Morning.
Martin Stewart, Tom Ward with Joe Koenig.
Good morning. We're informed that the jury has reached a verdict. You'll get them in just a moment here. Couple of things before we do that. Obviously, criminal cases are often very emotionally charged. They mean a lot to the people involved and to the people observing, and certainly victims' families of the accused, and a lot of other people. And this case certainly has a high degree of that, and it's understandable. So I understand there will be reactions to whatever happens. I ask that we respect the work of the jury, even if it's something you disagree with. So people can, appeals can happen, things like that. Whatever happens from here, please respect their work and do not react openly or outwardly toward them based on what they've done and what they've decided. Second, there are many charges. There's 19, so I have to review them before I announce them. So that'll take a moment. So just letting you know that. And finally, they will be instructed that it's up to them whether they speak to anyone. So if they decline to speak to people after the verdict has been reached, please respect that. Ready for the jury? One final comment. Any conversation necessitating the name of a juror will be muted from the live streaming. Per the court's prior order.
I don't think this judge plays much. He doesn't take anything. I think we are waiting on the jury now. I want to play the verdict music, but I don't think it's appropriate right now. I don't know. We've already kind of briefly played it. Yeah, but he's a good judge. I like him. Yeah, I do like him too. But, well, just pretend I'm playing the verdict music. I mean, there you go. All right, jury's coming in with the verdict, 19 charges. Let's get to it. It's going to take a little bit for the judge to read the charges, to take it in the verdict himself, but we'll get it done because it's 19 charges to go through. So, whew,
Please be seated.
there you go. Here we go.
Welcome back, members of the jury. Good morning. It looks like we have our foreperson. You're holding a lot of papers. Are you the foreperson?
Yes, Your Honor.
And we understand the jury has reached a verdict in this matter. Is that the case? Are the verdicts unanimous on all counts?
Yes, Your Honor.
Would you please hand that to the bailiff?
All right, now the judge is just going to review them. There's 19 charges, so it's going to take him a hot minute, and then he's going to probably just making sure that the forms are done properly, because we've been in several cases that the paperwork was not good done. Oh, hey, Seeking Justice. Hello, welcome, and thank you very much for the support. You did just get here on time. Thank you very much for all you do, and you do help the channel as well so much. I really, really appreciate it. Uh, oh, yay! I can see his face when he like, oh, I wish we could do that here too, but I do have the magnifying glass, but it doesn't work. I can always put a little bit smaller and see if it works in on like this. This looks better. We can look better, like zoomed in him. You guys can just see there. Let me have a look. Let me actually try something while the judge is doing that. No, it doesn't work. What I was thinking doesn't work. Never mind. But I can do this with the magnifying glass, that you kind of see him a little bit better. Yeah, that microphone is in a way. That microphone should get out of there, but yeah. So let me put full screen again. So we are just, it is a bit blurry, but that's the feed. I am so sorry. It's not great. Hey Anne, hello, welcome in again. Welcome in. Hi, so good to see you. It is you. Yes, you definitely just in time for the verdict. Oh, I think the judge is done reading. Oh, judge is gone. Oh, judge is back. Yeah, I think he might stand actually. I don't know. Yeah, we have sound, so.
Jury verdict, count 1, charge of murder in the first degree pertaining to Alexa Bartell. The foreperson has signed Roman numeral 2 and marked the first box under it. We, the jury, find the defendant, Joseph Edwin Koenig, guilty of murder in the first degree, signed by the foreperson. Jury verdict, count 2, charge of attempt to commit murder in the first degree regarding Max Mueller. Foreperson has signed under Roman numeral 2 and marked the first box. We, the jury, find the defendant, Joseph Edwin Koenig, guilty of attempt to commit murder in the first degree, signed by the foreperson. Jury verdict, count 3, charge of attempt to commit murder in the first degree regarding Charles Getz. The foreperson has signed under Roman numeral 2 and marked the first box. We, the jury, find the defendant, Joseph Edwin Koenig, guilty of attempt to commit murder in the first degree, signed by the foreperson. Jury verdict, count 4, charge of attempt to commit murder in the first degree regarding William Groves Smarr. The foreperson has signed under Roman numeral 2. We, the jury, find the defendant, Joseph Edwin Koenig, guilty of and mark the first box, attempt to commit murder in the first degree, signed by the foreperson. Jury verdict, count 5, charge of attempt to commit murder in the first degree regarding Eleanor Davis. The foreperson has signed under Roman numeral 2 and marked the first box. We, the jury, find the defendant, Joseph Edwin Koenig, guilty of attempt to commit murder in the first degree, signed by the foreperson. Jury verdict, count 6, charge of attempt to commit murder in the first degree regarding Nathan Tipton. The foreperson has signed under Roman numeral 2 and marked the first box. We, the jury, find the defendant, Joseph Edwin Koenig, guilty of attempt to commit murder in the first degree, signed by the foreperson. Jury verdict, count 7, charge of attempt to commit murder in the first degree regarding Brian Smith. Foreperson has signed under Roman numeral 2 and marked the last box. We, the jury, find the defendant, Joseph Edwin Koenig, guilty of reckless endangerment, signed by the foreperson. Jury verdict, count 8, charge of assault in the second degree regarding Max Mueller. The foreperson has signed under Roman numeral 2 and marked the second box. We, the jury, find the defendant, Joseph Edwin Koenig, guilty of assault in the third degree. Jury verdict, count 9, charge of assault in the second degree regarding William Groves Smarr. The foreperson has signed under Roman numeral 2 and marked the second box. We, the jury, find the defendant, Joseph Edwin Koenig, guilty of assault in the third degree, signed by the foreperson. Jury verdict, count 10, charge of assault in the second degree regarding Eleanor Davis. The foreperson has signed under Roman numeral 2 and marked the second box. We, the jury, find the defendant, Joseph Edwin Koenig, guilty of assault in the third degree, signed by the foreperson. Jury verdict, count 11, charge of attempt to commit assault in the second degree regarding Charles Getz. The foreperson has signed under Roman numeral 2 and marked the second box. We, the jury, find the defendant, Joseph Edwin Koenig, guilty of attempt to commit assault in the third degree, signed by the foreperson. Jury verdict, count 12, charge of attempt to commit assault in the second degree regarding Nathan Tipton. The foreperson has signed under Roman numeral 2 and marked the second box. We, the jury, find the defendant, Joseph Edwin Koenig, guilty of attempt to commit assault in the third degree, marking the second box, and signed by the foreperson. That was attempt to commit assault in the third degree, second box, marked by the foreperson. Jury verdict count 13, charge of attempt to commit assault in the second degree regarding Brian Smith. The foreperson has signed under Roman numeral 2 and marked the second box. We, the jury, find the defendant, Joseph Edwin Koenig, guilty of attempt to commit assault in the third degree, signed by the foreperson. Jury verdict count 14. Charge of attempt to commit murder in the first degree regarding Christopher Bryan. The foreperson has signed under Roman numeral 2 and marked the second box. We, the jury, find the defendant, Joseph Edwin Koenig, guilty of attempt to commit murder in the second degree. Jury verdict count 15. Charge of attempt to commit assault in the second degree regarding Christopher Bryan. The foreperson has signed under Roman numeral 2 and marked the second box. We, the jury, find the defendant, Joseph Edwin Koenig, guilty of attempt to commit assault in the third degree, signed by the foreperson. Jury verdict count 16. Charge of attempt to commit murder in the first degree regarding Michael Marasco. The foreperson has signed under Roman numeral 2 and marked the third box. We, the jury, find the defendant, Joseph Edwin Koenig, guilty of attempt to commit reckless manslaughter, signed by the foreperson. Jury verdict count 17. Charge of attempt to commit murder in the first degree regarding Shannon Sela. The foreperson has signed under Roman numeral 2 and marked the third box. We, the jury, find the defendant, Joseph Edwin Koenig, guilty of attempt to commit reckless manslaughter, signed by the foreperson. Jury verdict count 18. Charge of attempt to commit assault in the second degree regarding Michael Marasco. The foreperson has signed under Roman numeral 2 and marked the second box. We, the jury, find the defendant, Joseph Edwin Koenig, guilty of attempt to commit assault in the third degree, signed by the foreperson. That's the second box, attempt to commit assault in the third degree. Jury verdict count 19. Charge of attempt to commit assault in the second degree regarding Shannon Sela. The foreperson has signed under Roman numeral 2 and marked the second box. We, the jury, find the defendant, Joseph Edwin Koenig, guilty of attempt to commit assault in the third degree, signed by the foreperson. Mr. Foreperson, did I read those correctly?
Yes, Your Honor.
Is there any request to poll the jury? Or by the people?
No, Your Honor.
Members of the jury, you have now completed your duties as jurors in this case, and you are discharged with the profound thanks of this court. The question may arise whether you may now discuss this case with the lawyers, the defendant, or other persons involved in the case. For your guidance, the court instructs you that whether you talk to anyone is entirely your own decision. It is proper for others to discuss the case with you, and you may talk with them, but you need not do so if you decide not to. If you talk to them, you may tell them as much or as little about as you like about your deliberations or the facts that influenced your decision. If any person persists in discussing this case over your objection or becomes critical of your service, either before or after any discussion has begun, please report that to me. With our profound thanks, you're excused at this time. I'll come back to thank you in person briefly before you head out on your way. Thank you all very, very much for your time, your attention, and your service.
Wow. Thank you very much, Tori, for your service. 19 out of 19 charges guilty across the board. So I think next is not the penalty phase, but you know what I mean, the sentencing. There's only one sentence that he is facing. It's life with...
Please be seated.
Judge interrupted me.
Bond is revoked at this time. As to timing of sentencing, is there a request for PSI?
Not from the people.
What timing do you all prefer? And when PSIs are requested on either side, the court will honor that request usually, and will do so here. So the court will order the pre-sentence investigation. That will take approximately 4 weeks. We are at April 25th. Take us to about May 23rd. Let's see what is available.
And the people are unavailable on the 23rd.
May 28th or 27th even. Those both look pretty good. How about the 27th?
I'm out of town that whole Memorial Day week. Would you do the first week of June?
Yes. Does that work? How about June 3rd? With you?
That works for the people.
8:30?
Your Honor.
We will set sentencing June 3rd at 8:30. The court will order the pre-sentence investigation. How long do we think? Any sense?
The family would obviously like to speak at that sentencing, like the sentencing's next week. So if we could allot, we may not use it, but allot a couple of hours.
Is the morning sufficient?
The morning would be sufficient.
Seem okay with you? Okay. We'll set aside the morning of June 3rd as previously discussed, beginning at 8:30. Sentencing will be at that time. Anything else at this time for the people
No, Your Honor.
or the defense? Thank you. The exhibits will be returned per procedure. We'll see everybody June 3rd. Thank you.
Thank you.
All right. Bye bye, Joseph. Take him away. And he's gone to probably, yeah. Yeah, if he gets parole, I don't think he's ever gonna lower it. So he's gonna go away from jail. Look at what happened with Stacey Rodriguez, the case that we covered exactly from this court. Discounted this state. It was exactly this. So I don't think so. He is, well, no matter what, his life is over. And he's gonna get what he deserves. He's gonna be in jail, prison for the rest of his life. And in my opinion, that's what he deserves. He's suffering the consequences of his actions. He should have thought twice or three times before he did what he did, and now he just has to suffer the consequences of such. It is heartbreaking for both sides, for the family side of Joseph, and for as well the victim side, Alexa's family, and all the other victims included, especially for the family of Alexa. They not gonna get their daughter, granddaughter, sister back, due to his actions and due to this stupidness that he did. So I'm glad that justice was served for all the victims, including Alexa, and that he's now gonna pay, and as he deserves. I made a note of the date. If we are not in the middle of a trial, indeed, bye bye, I vamos. If we are not in the middle of a trial, we're gonna follow the sentencing. but we can probably amend to be able to attend to the sentencing. So we're gonna make sure that we are there for that part, because even though we only covered a bit of this case, we all got involved in it and we got invested, and I want to watch it, and we're gonna see the comparison how he looked today to what he's gonna look in 2 months time, well, a month time. So yeah, so now the family is hugging each other, because I'm sure they sadly bonded over to through this tragedy, and they got at least a bit of closure and justice. So that is good to see. Okay, now what we're gonna do, what I was planning, because we have still a couple of hours to our next sentencing. What we can do is we can do the sentencing that Zio was telling us about, the Walmart guy. We can watch that one, watch a little bit of a preview of the sentencing for tonight, and then I could have a couple of hours off to rest and take a nap and eat some food and just maybe do nothing a little bit, and then we would come back for the other sentencing. What do you guys think? Do you agree with that? Are you okay with that? Because I know the other sentencing is gonna probably take a couple of hours to get through and everything, and then we could just um do that, because it's gonna be probably a little bit late into the late night of my time zone, and then we could do that. What do you guys think? Do you agree? Do you not agree? Do you want just me to stay on forever and not bring any breaks? Um, so it is a very sad case, though, the sentencing that is gonna happen. Um, but I would like to see, because the facts of the case. So yeah. So no, obviously, absolutely, no worries. I'll see you very soon. No worries. So, oh yeah, no worries. I'll see you very soon, guys, and we'll do that. We'll watch just this Texas Walmart pew pew incident that happened, and then we'll go off for. Oh, what did I do? Why do I press the wrong button all the time? My dice. I need to stop pressing buttons. So I'm gonna share this tab now, and we're gonna watch that while I put the other stream up. So I know the sound is gonna be a bit louder. Let's watch this one. Oh.
All right, please. Be seated, please. These are cause numbers 2020-0D02631 and 2023-0D05832. State of Texas versus Patrick Wood Crucius. We are here this morning on pleas of guilty. May we have announcements of counsel?
Good morning, Your Honor. James Montoya, Rebecca Tarango, and John Davis from the state. The state is ready.
Good morning, Your Honor. Mark Stevens, Felix Valenzuela, and Joe Spencer on behalf of Patrick Crucius, we're ready to proceed.
Please stand, raise your right hand for me, please. Do you swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God?
Your Honor.
So Article 39.14 of the Code of Criminal Procedure is the discovery provision in Texas. I have signatures by you, your lawyers, and the attorney for the state indicating that the Michael Morton Act has been complied with. Is that correct, Mr. Stevens, Mr. Spencer?
It is, Your Honor.
Mr. Montoya?
It has, Your Honor.
Sir, in the 2020 cause number, you have been charged by indictment with the offense of capital murder. The range of punishment for this offense is life in prison without the possibility of parole. In the 2023 cause number, you have been charged by indictment with 22 counts of aggravated assault with a deadly weapon. These offenses are second-degree felonies, punishable by confinement in the institutional division of the Texas Department of Criminal Justice for a term of not more than 20 years, nor less than 2 years, and fines not to exceed $10,000. By entering your pleas of guilty here today, you may be waiving or giving up some very valuable and important rights, like the right to remain silent, the right to confront and cross-examine the state's witnesses, and most importantly, the right to have a jury trial in these matters. Do you understand the rights that you currently have?
Yes, Your Honor.
Do you understand that you could be waiving or giving up these rights by entering your pleas here today?
I do.
Sir, I have in front of me what has been marked as State's Exhibit Number 1. They are the plea papers in these cases. They are two separate documents under the respective cause numbers. Are these your signatures on these documents?
Yeah, Your Honor.
Before you signed them, sir, did you read them?
Yes, sir.
Did you understand them?
Yes.
Mr. Stevens, Mr. Spencer, Mr. Valenzuela, did you explain the plea papers to your client?
We did, Your Honor.
And is your client legally competent to enter these pleas?
After numerous conversations with our client, we believe he is competent to proceed today, Your Honor.
Sir, where were you born?
Dallas, Texas.
Under cause number 2020 0D0 2631 to the offense of capital murder as alleged in the indictment, do you wish to enter a plea of guilty or not guilty?
Guilty.
And under cause number 2023 0D0 5832 to the 22 counts of aggravated assault with a deadly weapon as alleged in the indictment, do you wish to enter pleas of guilty or not guilty?
Guilty.
And are you pleading guilty because you are guilty and for no other reason?
Yes, Your Honor.
Mr. Montoya, what is the plea agreement in these cases?
Your Honor, in exchange for the defendant's plea of guilt and a complete waiver of his appellate, post-conviction, and any potential executive clemency, the state is withdrawing its notice of intent to seek the death penalty in the 2020 cause number for a sentence of life with no possibility of parole. And then, Judge, with respect to the 2023 cause number, it is 22 counts of aggravated assault enhanced with a bias and prejudice finding, bumping those up to first-degree felonies. And so we would, 22 counts of life.
Of life?
Yes.
Mr. Crucius, I overlooked the fact that they were enhanced. So the range of punishment for the 2023 cause number is confinement in the institutional division of the Texas Department of Criminal Justice for a term of life or 99 years, but no less than 5 years, and a fine not to exceed $10,000. So the 2 to 20 I talked about earlier has been enhanced to that. Do you understand this?
Yes, Your Honor.
And is it still your intention to plead guilty to the 2023 cause number, knowing what the range of punishment is?
It is.
Okay. And you said it's going to be life on all 22 counts?
Yes, sir.
Mr. Stevens, Mr. Spencer, Mr. Valenzuela, is this your understanding of the plea agreement?
It is, Your Honor.
Sir, is this your understanding of the plea agreement you've reached with the state of Texas?
Yes.
And have you seen and signed the court's notice to you about your rights and the court's certification of those rights with regard to any appellate issues that may or may not have been resolved?
I have.
Mr. Montoya, please summarize the evidence.
Yes, Your Honor. Had the state proceeded to trial, the state would have proven beyond a reasonable doubt that on August 3rd, 2019, the defendant in El Paso County did then and there intentionally cause the death of multiple individuals in the same criminal episode, to wit, Andre Pablo Anchondo, Jordan Jamrowski Anchondo, Arturo Benavides, Leonardo Campos Jr., Angelina Silva Inglesby, Maria Munoz Flores, Raul Estrada Flores, Jorge Calvillo Garcia, Guillermo Cochmemo Garcia, Adolfo Ceros Hernandez, Maribel Hernandez Loya, Gerhard Alexander Hoffman, David Alva Johnson, Luis Alfonso Juarez, Ivan Manzano, Gloria Irma Marquez, Elsa Mendoza, Sarah Esther Regalado Monreal, Margie Record, Javier Amir Rodriguez, Maria Eugenia Legareta Roth, Teresa Sanchez, Juan de Dios Velazquez. We were shown that the defendant caused their death with a firearm, to wit, a WASR-10 rifle, by shooting them about the body. Furthermore, the state would have proven beyond a reasonable doubt that the defendant intentionally, knowingly, or recklessly caused bodily injury to Enrique Atilano, Luis Ever Calvillo, Mario de Alba Montes, Erica de Alba Rodriguez, Oliva Rodriguez Mariscal, Jessica Garcia, Michelle Grady, Maribel Latin Sainz, Ernest Christopher Grant, Liliana Munoz Puente, Jeremy Avila, Octavio Lizarde, Martha Juarez, Rosa Calderon, Mario Perez Briones, Rosa Baron, Rosemary Vega, Monica Arciniega, Ana Gonzalez, Maria Magdalena Gonzalez Garcia, Alma Enriquez, and Nicolasa Mena de Velazquez, also by shooting them about the body with a firearm. Furthermore, the state would have proven beyond a reasonable doubt that the defendant was the author of a manifesto entitled An Inconvenient Truth that was posted on 8chan shortly before the shootings, that the manifesto was authentic and authored by the defendant, and that the offense was committed because the defendant possesses a bias or prejudice, a group of individuals identified by their race, color, national origin, or ancestry.
Any objection to the introduction of States Exhibits 1, 2, and 3 under the respective cause number?
Your Honor, after already having had an opportunity to examine all the exhibits, we have no objections.
States 1, 2, and 3 will be admitted into evidence. The court is aware that we will be going into victim impact statements for the rest of the week. Based on the evidence presented here today and on your pleas of guilty, I will accept your pleas and at this time find that the evidence does substantiate your guilt. In cause number 2023-0D05832, I do find you guilty of 22 counts of aggravated assault with a deadly weapon that has been enhanced to first-degree felonies. And under each count, I hereby sentence you to confinement in the institutional division of the Texas Department of Criminal Justice for life terms. In cause number 2020-0D02631, I do find you guilty of capital murder, and I sentence you to confinement in the institutional division of the Texas Department of Criminal Justice for a term of life without the possibility of parole. Have you understood everything that's happened?
Yes, Your Honor.
Anything from the defense or the state? Do you wish to make any statements?
I do, Your Honor. I just wanted to thank the El Paso Police Department for the work on this case, as well as the other first responders, local, state, and federal that responded to the scene on August 3rd, 2019, as well as for the investigative work by the El Paso Police Department and the Federal Bureau of Investigation. I also wanted to thank the County of El Paso, the court, the county judge, and the commissioners for allowing us to use this room for the plea and for allowing everyone to be present. I also wanted to take a moment, Your Honor, on behalf of the state of Texas to apologize to the community and the court, and specifically the family of Gerhard Alexander Hoffman for the gross and abominable misconduct by one of my predecessors and her representatives acting as representatives of the state of Texas, and their manipulation and terrorizing and frankly the re-victimization of Mr. Hoffman's family during the pendency of this proceedings. And lastly, Judge, there's a lot to say about the defendant and the hateful ideology that motivated him, and that there are other public figures and elected officials that espouse and promote this ideology. But my sincere hope is that for the rest of this proceeding, this afternoon and the next few days, and moving forward, that the focus can remain on the 23 lives that were taken from us far too soon, their family members, and the survivors of this horrific event.
Mr. Spencer, is there anything you wish to say, or Mr. Stevens?
May it please the court. We stand here today in the shadow of an unimaginable tragedy. On August 3rd of 2019, Patrick Cruces inflicted a wound on our community that may never fully heal. He brought violence and terror to a place of peace, shattering lives and forever changing the landscape of El Paso. To everyone who lost loved ones, to those who were injured, to everyone whose sense of safety was violated, we offer our deepest, most sincere condolences. We know that the pain runs deep and cannot be erased. Today, Patrick Cruces pleaded guilty to the charges brought against him by the state of Texas. He has accepted responsibility for this horrific actions. This plea, following his guilty plea in federal court and the resulting 90 consecutive life sentences, brings judicial finality. In federal court, Patrick Cruces publicly expressed remorse for the first time when confronted by one of his victims. Patrick will spend the rest of his natural life in prison. He will never again walk free. Patrick will leave prison only in a coffin on God's time. We hope that the resolution spares the victims of our community the further trauma of a protracted trial and decades-long appeals. But legal finality cannot erase the pain, nor does it fully answer the agonizing question, why? How could something so senseless happen here in our community? Over the past 5 years, extensive evaluations by numerous healthcare professionals have concluded that Patrick Cruces suffers from a severe debilitating mental disease, schizoaffective disorder. This illness involves profound breaks with reality, including hallucinations and deeply entrenched delusional thinking. His thinking became increasingly divorced from reality, dominated by fixed, strange ideas, not based on fact. This wasn't sudden. It was a slow unraveling. We share this not as an excuse, but as part of the explanation for the inexplicable. It is crucial to understand that Patrick's severe mental illness made him exceptionally vulnerable to delusions based on racial misinformation. Untreated and isolated, particularly in the year leading up to this attack, his grasp on reality weakened. As his mind detached from reality and his illness set in, he experienced distressing, intrusive thoughts of violence. He searched the internet desperately for help for his mental illness. He withdrew from work, from school, and from his family. His own mother recognized his instability and unsuccessfully attempted to have law enforcement intervene regarding his firearm possession, but tragically, they did not. It was in this state of isolation and profound mental distress that Patrick turned to the darkest corners of the internet and absorbed the political discourse of the time. His illness wrapped his ability to distinguish reality from delusion, hate from non-hate. He became consumed by extreme ideologies found online on sites like 4chan and 8chan. He latched onto hateful rhetoric particularly the dangerous and false narratives surrounding immigration being repeated in political discourse. The political environment of 2019 was charged with incendiary language. Terms like invasion were used repeatedly in political discourse to describe immigrants and happenings on our border. This rhetoric, rooted in racist ideologies like the Great Replacement Theory, dehumanizes entire groups of people. While Patrick claimed in his manifesto that his views predated the then president and that political figures were not to blame, he also explicitly stated the attack was a response to the Hispanic invasion of Texas, echoing the language used by political figures. Indeed, Patrick believed he was acting at the direction of the president at the time, seeing it as his duty to stop the invasion, because that's what he believed the president was telling him. Those thoughts became cemented in the vulnerable, broken brain. This is the crux of the senseless Patrick, unable to parse reality, absorb toxic rhetoric that casts fellow human beings as a threat. Dehumanizing language, especially when amplified by figures of authority and spread rampantly online, can and did, in this case, have deadly consequences. It poisons minds, particularly those vulnerable due to mental illness or isolation, and validates horrific violence. When groups of people are described as an invasion or a replacement, it strips them of their humanity and positions them as targets. Let me be unequivocally clear. This explanation of a severe mental illness and toxic political environment does not in any way justify or excuse the horrific violence that Patrick committed. He bears responsibility for the choices he made and the devastation that he caused. He pleaded guilty, and he will face the consequences for the remainder of his life in the harshest conditions of confinement. The strength and resilience of the El Paso and Ciudad Juarez in the face of this horror has been extraordinary. This community, our community, represents the very opposite of the hate that drove the attack. It is a place of connection, of faith, and of cross-border kinship. Patrick failed in his mission to sow division here because the bonds of this community are strong. Moving forward, the focus must shift entirely to the needs of the survivors, the families of those lost, and the healing of our community. We heard the powerful impact statements, the stories of loss, pain, and fear, but also of incredible faith and resilience at the federal sentencing. We must continue to listen and to support and to provide resources needed for healing, however long it takes. We hope that today marks a step, however small, towards healing for all of those affected. May we honor the memory of those lost by rejecting hate, championing compassion, and working tirelessly to build a future where such tragedies are unthinkable. Que Dios los bendiga a todas las víctimas, nuestras familias y nuestra comunidad del Paso y Ciudad Juárez. Thank you for allowing me the opportunity to speak to you.
The court wishes to address you at this time. On August 3rd, 2019, you traveled 9 hours to a city that would have welcomed you with open arms. You brought not peace, but hate. You came to inflict terror, to take innocent lives, and to shatter a community that had done nothing but stand for kindness, unity, and love. You slaughtered fathers, mothers, sons, and daughters. You left wounds that have yet, after such horror, you are guaranteed the rights that every person is entitled to under the law. Now, as you begin the rest of your life locked away, remember this: your mission failed. You did not divide this city, you strengthened it. You did not silence its voice, you made it louder. You did not instill fear, you inspired unity. El Paso rose, stronger and braver. The community you tried to break has become a symbol of resilience, of love overcoming hate, of humanity enduring in the face of evil. This community will always remember those whose lives you stole, their names, their stories, their accomplishments. Their light will never fade, while you, your name and your hate, will be forgotten. This course will stand adjourned until 1 o'clock.
Wow. That definitely a big applause for that statement for the from the judge. Short, sweet, but sweet. Very good indeed. And I agree. We only saw 23 minutes out of this whole situation, and I only known this case since Lizzie brought it to my attention, and I really appreciated that we could show this out, because this guy, I need to take him out of my screen because I can't even see him anymore. It just makes my skin crawl. And I hope he rots in jail or in prison for the rest of his life, and that he's made someone's for the rest of his life, because that's what he deserves. That's all that I'm gonna say. Okay, now before we go, we're gonna have a preview of the sentence that we're gonna see, and I've closed the freaking case overview that I was gonna read. Hang on, I need to bring that up. I closed the tab. Hang on, bear with me, because obviously I am not ready again. Hang on. And so, we are going to come back in about 2 hours to listen to a sentencing. So, this is not what I wanted to. This is what I want. So, I'm going to read to you a little bit of what happened, and then we're going to see a little bit of something that, boyfriend would be the word the word for YouTube, but I was thinking of you know the other word, the other B word. So this case is out of Washington, Seattle. A teenager, Chase Jones, 19, is facing the life in prison on unaliving 4 people and injuring 2 others in a high-speed crash. So it reads, Jace Jones, 19, pleaded guilty to 4 charges of vehicular homicide and 2 charges of vehicle assault for a deadly crash on March 19, 2024. Jones was driving his new Audi A4 at over 100 miles per hour when he burled through a red light and crashed into a van driven by Andrea Hudson. Hudson, 38, was driving a carpool and was one of 3 people instantly killed in the crash. Boyd Buster Brown, 12, Matilda Tilly Wilcoxon, 13, and Eloise Lou Wilcoxon, 12, were also in the van and declared dead at the scene. Hudson's children, ages 14 and 11, were also in the car and survived the crash with very serious injuries. Hudson was crossing the intersection on a green line when her van was hit by Jones' vehicle with an impact so strong that it compressed the passenger compartment of the car approximately 3 feet. Firefighters had to cut the roof of the van to recover the victims. Data extracted from the Audi revealed that he had been traveling 111 to 113 miles per hour in the moments before the crash, and the brake pedal was never touched. Prosecutors said that Jones had just got in the A4 1 month before the crash, after totaling 2 other cars in crashes where he was also accused of speeding. So he already had 2 speeding charges before this one. The maximum sentence for the 4 counts of vehicle homicide is life in prison, but prosecutors have agreed to recommend 210 months for the 4 counts of vehicle homicide and 84 months for the counts of vehicle assault to be served concurrently. So hang on. What? Oh, that's the maximum that I agreed to recommend. That they doesn't mean that they are gonna follow. So how long is 210 months? Hang on. How long? How many years is 210 months? So that's 17 years. So they recommended 17.5 years for the homicide, right? And then the 84 months plus 7, so 20 17 18 19 20 21 22 20 23 years altogether. That's the recommendation from the prosecution. Yeah, you were very close indeed. Well done, Paula. I'm very impressed. Your math skills are on point. So literally the prosecution has recommended 23 years and a half for the vehicle homicide and the attempted of the vehicle assault, but is the maximum is life in prison. Wow, that is crazy. We'll see what the judge, he did plead guilty. So on, because this is going to be from Court TV, they have a little trailer that plays before the live stream starts. So it is very fast, so kind if you can't pay attention, but it goes by very 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 fast. So I'm just going to play that preview of the trailer that they have on it for this hearing.
Just before 1 in the afternoon, March 19th, 2024, Andrea Hudson is driving her minivan through a residential area of Renton, Washington, a suburb of Seattle. In her car, 2 of her own children and 3 others, all part of a homeschooling collective. This surveillance video obtained by Como News shows Andrea waiting at a light. When the light turns green, she's the second car through the intersection, and that is when a blue Audi A4 traveling 112 miles an hour runs a red light and plows into Andrea's Toyota Sienna. The impact sent her minivan into 2 other cars before flipping several times. Both the minivan and the Audi traveled more than 125 feet before coming to a stop. First responders found Andrea and 3 children in her car dead at the scene. 2 others were life-flighted in critical condition. Andrea Hudson was 38 and the mother of 3. Boy Buster Brown was just 12. Sisters Matilda Tilly and Eloise Lou Wilcoxon were just 12 and 13 years old. Andrea's 12-year-old daughter Charlotte and 14-year-old son Nolan spent weeks in the hospital. The driver of the Audi, 18-year-old Chase Jones. He had a broken leg and needed surgery.
Mr. Jones, you have been charged in count 1.
Jones was arraigned from his hospital bed on 4 counts of vehicular homicide and 2 counts of vehicular assault. The investigation revealed 2 previous excessive speed-related accidents involving Chase Jones, both within a year of the fatal accident.
I'm a little concerned and shocked that there has been to my knowledge, no attempt to reach out to us or the Browns or Hudsons with any kind of message of sympathy or regret.
Okay, so that is the sentencing that we are gonna be watching later today. It says there 8:45 p.m., but that's my time. So it's in about 2 hours. I know it's absolutely crazy. Like if you watch the footage again, you can't even see the car. He's going so fast that you can't even see the car. You see the Andrea's car flying away, but you can't even see the other car, which is absolutely crazy. it's absolutely, oh my days, it's such a heartbreaking guys, but I feel like we have to listen it and to get justice for these victims and see another person going to prison for a very long time, because I like that. They deserve it. They committed the crimes. So we can refresh a little bit and have a little bit of a break. I am going to leave this stream here. We are going to come back in about 2 hours. I've already created the other live stream, and you're going to be automatically teleported to the new one. So make sure that you have your seatbelt on, your arms inside, because we are going to travel to the new stream. I will try to be there, but I'm going to take maybe a little bit of a nappy nap to rest, because it's going to be a long night and it's going to be emotional. But we'll be back. Don't worry. So until then, I'll see you guys very soon. Thank you for hanging out with me. Have a great afternoon, evening, wherever you are, and I'll see you in about 2 hours. Thank you. Bye.
And I'm a real-time crime professional.